Good morning. Good morning. We are going to begin this public hearing in the Judiciary Committee for today, Friday, March 15th, 2024. I have a couple of people signed up. We'll get through the list. When you come up, you get 3 minutes to provide us with your testimony. At the end of the 3 minutes, if you haven't finished, I will remind you that you have 3 minutes to provide your testimony and ask you to wrap up. That is not a signal to continue testifying. That is a signal to figure out how you wrap up. Should you choose not to do that, I will remind you again, and hopefully that will be the end of that. When you come up, there is a microphone in front of you. It is a microphone that has a red light that illuminates when it is on, and when it's not on, it's not illuminated. Press the red button to do so. We will begin with John Delia.
Good morning. My name is John Delia, and I represent Haiti Silva versus State of Connecticut in file number 22987. And the case involved a May 2012 personal injury that occurred at the UConn campus. My client was attending a graduation of her grandson or granddaughter at that time. She was injured when she stepped in a hole in the sidewalk on UConn property and sustained some personal injuries. As I said, the injury was in 2012, but unfortunately, there was no hearing on the matter until 2017, some several years later, and no tape was ever provided to us of the hearing. So there was an audio tape made, and there was no decision ever rendered, and no audio tape was ever provided to us. Then it was not until 2023 that a written decision was made by Claims Commissioner Robert F. Shea Jr. with extremely limited reasoning specified in the decision for the negative decision that came out. The decision was unfavorable to our client. The statement was made, it contained very little reasoning. It indicated that the Claims Commissioner did not think that the place where the claimant fell was a defect, but he indicated in a citation, a legal citation involving a case that really had nothing to do with our case, because our case involved a hole in the sidewalk. The citation involved 2 sidewalk panels that were of different or varying levels, which really isn't the same thing as our case. So the decision's defective for many reasons. Number one, a different person made the decision than the person that saw my client and saw the witnesses in the case. Really, under most normal circumstances, this happens occasionally where a judge becomes ill or dies or something like that during a trial. And the most typical thing that happens in this situation is that there's a mistrial declared, not a tape which isn't disclosed to the parties that is then looked at by some other commissioner who makes a decision without seeing any witnesses. So our feeling is that this decision was completely unfairly rendered, contained incorrect, improper reasoning. The claimant was made to wait 10 years for the decision, which is fundamentally unfair all by itself. The trial testimony was really our client and then the investigating State of Connecticut officer who really didn't testify against our client. She didn't provide any evidence that rebutted or refuted any of the claims being made by the claimant. And so we think that really the only proper way to address this now is to give the claimant another opportunity, which would be a lawsuit against the state or a fact finder who sees the claimant testifying and assesses all of the evidence can have the opportunity to do that in one
Your time has expired, Attorney Delia.
Thank you very much.
Thank you. Questions from the members of the committee. Representative Fishbone.
Thank you, Mr. Chairman. Good morning, sir. Thank you for coming here.
Thank you.
So, listening to your citation of the facts, the trier of fact that was determining whether or not the matter should proceed went away. Either, resigned, but they weren't ultimately the one that made the decision. Is that fair?
That is correct. And as a matter of fact, I don't even know who that person is. A person came into the room and said, I am your hearing representative or hearing officer. She was having difficulty with the tape recording device, but we were told to present the hearing, and so we presented the hearing. I don't know who the person is that heard our case, and we never got a tape from the hearing.
Okay, no, I appreciate that. And certainly we are trying to clean up this process. My concern is that perhaps due process has not occurred here. So let me try and make a suggestion. I mean, it's been a long time, right?
Very long.
I concur on that one. I think our procedure would call for, I mean, if a judge hears a case and they have a 120-day rule to render a decision and they pass away during that period of time, therefore unable to act, it's a mistrial. So, and you start all over again. Would it be amenable to you if the claims commissioner just heard the matter and due process occurred?
Well, the issue with that is that a decision's already been rendered, and I would feel that would also itself be another fundamentally unfair thing to be trying a case in front of someone who's already made a decision. If it's the only way, if it's the only remedy for us, we'd be agreeable. But if we're being asked if we have a choice, we would want a different court and a different forum and a different judge.
Yeah, I understand. I'm just looking at the gatekeeper function of the claims commissioner's office. So I know the claims commissioner is here. I know the claims commissioner will more than likely give us his opinion on the matter, but this is your opportunity. So I appreciate the exchange. It's a difficult situation to deal with, and perhaps remedy is difficult also. So thank you. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee. Senator Kissel.
Thank you very much. I'm just wondering, for my edification, what kind of injuries your client suffered?
She had some wrist and back and spine injuries.
My colleague believes it's soft tissue. Was there any permanent disability
There's
determination?
permanent impairment. There were no fractures or surgery or anything like that, but it was an injury that did involve permanent impairments.
So essentially, your client alleges that she went to this graduation, was walking, probably looking forward, stepped into a hole that shouldn't have been there in a sidewalk, and tripped and fell.
That's correct.
Okay, thank you.
Thank you.
Thank you, Senator Kissel. I'm looking online and I don't recognize this name as a committee member, but someone could be in with a different device because it looks like they're on a panel.
I apologize. I meant to hit attendee and then I accidentally hit panelist.
Okay. All right. Thank you. Rep Fishbon, again, for the second.
Thank you, Mr. Chairman. Sir, you did give us a case number. I think it's the claims commissioner case number 22987. Do you know on our agenda which matter is yours? Because we use resolution numbers.
It was in my computer and now I'm on the screen here with you folks. I don't know if this helps. I think we were number 22 on the list.
Okay, that's
I don't know if that helps at all.
resolution
I think that's right.
174, the claim of Haiti Silva.
Yes, Your Honor. Yeah, yes, sir. Yes, sir.
Okay, thank you. Just for clarity. Thank you. Thank you, Mr. Chairman.
Thank you. Comment or question from other members of the committee. Comment or question from other members of the committee. Seeing none, Attorney I shouldn't have done it. Delia, thank you for joining us this morning.
Thank you for your time. Appreciate it.
Mr. Walker, you are up now. Anthony Walker? We were just talking to you. Okay, well, I know you're there somewhere. We'll come back to you. Angel Cortez.
Hello?
Mr. Walker,
Hello?
Cortez, 1 second. Mr. Cortez is just about to sit down. We'll come right back to you right after him. So just don't go away this time.
Okay, I tried to talk as an attendee. It wouldn't let me.
It's fine. We'll come right back to you.
Okay.
Make sure your microphone is on, Mr. Cortez, and you may provide us with your testimony.
Sorry, I'm having problems breathing. My name is Angel Cortez.
Mr. Cortez, just before you get too far, pull that microphone a little closer to you. There you go.
I think I just missed my turn going in the thing.
I can start now.
You may proceed.
Yes, my name is Angel Cortez. I've been having problems with the court system here. They've been taking my rights away from me and my daughter. They put me down as a military person. I'm not a military person. They allowed my daughter to leave the state of Connecticut without filling out the proper paperwork. The mother submitted paperwork stating that I was in the military. And I've been attacked by 2 different states when it comes out for child support. I've been paying child support in Florida, Connecticut. I've also been paying insurance in Florida and Connecticut as well. I basically got injured as well from workers' comp. They kind of not did their job properly, where I'm having problems breathing because of my injury. They never counted my knee. And I'm in a situation where I have to constantly keep waiting for disability. They did give me a hearing. They canceled the hearing. And basically I'm stuck in a situation where I have to wake up every day in the morning where I can't breathe. I don't know how to proceed in this situation because this is the first time. But my worst torture was when my daughter was taken away from me during the pandemic. I had a police officer that I called and I told him the situation, and no matter how many times I begged the police officer and told the police officer that the reason why my daughter ran away is because of my brother's wife. She's been influencing my daughter. And I kept telling him over and over. And to my surprise is that in the beginning of the pandemic, I was terrified because Florida was considered to be the 2nd deadly state of COVID. And it was I really can't continue right now.
Okay. Are you able to answer questions though? I understand you can't provide your test. Are you able to answer questions?
Yes.
Okay. I'll see if there are any. Representative Fishbaum.
Thank you, Mr. Chairman. Morning, sir.
Morning.
I'm just trying to figure out about your case. So you filed a claim with the claims commissioner, right?
Yes.
And just generally, what did you ask to do? I mean, usually people are looking to sue the state. For
Yes,
something,
I
right?
requested to sue the state for the wrongdoing and being in the situation where I'm being tortured, I'm being denied for disability, cash assistance, I'm not getting the proper help. I have an attorney that basically is telling me that the reason why they're denying me for disability is because I'm too young. And I told him that's prejudice. You can't just say that to me. And all he's saying over and over, I had a hearing and they canceled. And then they end up telling me that I finally got a hearing, but it's because I reported it to the governor's office. And I told them the situation, and I told them that I'm literally feel like I'm being blacklisted and I'm not getting the proper help. And it's to the point where I don't know what to do. We were almost on the verge of losing our apartment because I'm not able to pay. My girlfriend is the only one right now working, but ever since the pandemic, the restaurants haven't been the same. She haven't been making the amount that she been making. they're also attacking her financially. We've been
All right,
trying
we
to
just want
act.
to talk about your case, but I'm just trying to figure out. So you got denied disability by the federal government, right?
Yes,
Okay, and I'm just, and you would want to sue the state of Connecticut for the federal government denying your claim?
no, it's not only that, it's also because of my daughter. My daughter was also, was mentioned in the courtroom that she was getting beaten up by the mother, and they still turned around and sent my daughter back to the mother.
Okay,
I have not been given the rights to actually see my daughter, and I have rights where they said that I'm able to see my daughter on holidays, vacation. And I tried to do an appeal because she was not following the law. And no matter how many times they kept doing it, they still kept denying me. And they kept closing the case, and they have not allowed me to see my daughter. I missed every graduations. She just graduated, and to this day, I have not seen my daughter for almost 4 years.
so looking at our agenda, just for clarity's sake, your name is Angel Cortez, right?
Yes,
The matter that I see on our agenda, just for the record, is number 32. It's number one, joint resolution 184. You only have one matter on today, correct?
I have, yes, the case regarding of my daughter. I was not able to submit any other of my
Yeah,
injury because it happens after the pandemic. So when I submitted the paperwork, I was not injured at the time.
Yeah, I just wanted to make sure because some people have more than one matter on our agenda today. So, when we're talking about the case, I want to, be able to look at this particular case. Do you know why the Claims Commission dismissed your claim?
No, they're not giving me no information or anything like that. The
Well, How
first,
did you know to come here today?
I end up by some miracle, I was taking an Uber, and the gentleman that was riding on the Uber was a law student from Yale, or I think Harvard, and I told him the situation, and that's when he told me for me to come in here and to fight, and to also go to the appellate court and everything, to try to get some type of justice, because I was not getting any justice at all in the court system.
Okay, but I asked you about the dismissal and you said that you didn't get any paperwork at all.
What paperwork? The only paperwork I got was the guy that sent me a paperwork saying after 6 years that he wanted to dismiss this, when I submitted 700 pages of stuff that was like literally was not
Okay,
looked over.
so you knew about the dismissal. I'm just trying to get to.
Yes, I found
Hold
out.
on just a second. If
Yeah,
you-
hold on, Rep. You're gonna get a chance to respond.
Okay.
We want to all make sure that we're hearing the exchange and that we are clear about what we're hearing. So I get that this is very important. Let's try not to step over each other as much as possible.
Okay, sorry about that.
Oh, no problem. I'm just trying to, because this is your opportunity and, it's my opportunity to learn about your case, right? So do you know specifically why your case was dismissed?
In this situation, all I know is that I've been dismissing every single thing, even if I bring evidence or any of that situation. And I don't know why am I being dismissed when I have proof of what's going on.
Okay. So, and I'm not, at some point, usually the claims commissioner writes some sort of memorandum. And when they dismiss a case, it says, it's dismissed and this is why. So,
The guy wrote down on the paperwork saying that I don't have a strong evidence of anything. That's what basically the paper was. And I tried to call the number that was on the paperwork, but that was not answering. I had to call the governor's office and told them the situation, that they're not picking up the phone. I was leaving emails and everything. And they finally gave me a number that was not on the website. And all they end up telling me is that the people that work in that building, half of the people on one side was not working and they're working in the other side. And that's the reason why the phone was never been picked up.
okay, but you did see something to contest the dismissal.
Yes, I finally got a hold of somebody that ended up giving me the chance to do an appeal.
Okay, thank you. Thank you for coming here today and
Yeah.
thank you, Mr. Chairman.
Thank you, Representative. Comment or question from members of the committee. Comment or question. When was that phone call you made?
For to the governor's office.
That and subsequently to the commissioners?
I've been calling them nonstop for 4 years. I've been, don't-
But I'm referring to the time when you actually received phone numbers and they were able to.
I want to say probably like 3 or 4 years from now. I mean, sorry, 3 or 4 months from now that I end up hearing back from them, when they gave me the number. I don't know exactly what day.
No,
but it
I
was
don't
like
need.
around 3 or 4
I'm just-
months ago.
I'm just trying to get a sense of time frame. All right. Thank you. Comment or question from other members of the committee? Comment or question from other members? Seeing none, thank you very much for joining us this morning. Anthony Walker.
Am I able to leave because I'm
Yes,
here?
yes.
Thank you so much.
Anthony Walker.
Hello, yes, I'm here. Good morning.
You may proceed.
Okay, I'm here today because I filed the claim against the state in 2018. And according to the rules, then she had up to 2 years to respond. She responded 2 years and a month later and said she could not decide if she was going to agree or disagree with my claim. She kicked it to you guys, the Congressional Assembly. They kicked it back. You guys kicked it back to her and told her that she had to make a decision by September of 2020. She decided that she was going to dismiss the case for the same reasons that the state's attorney for the defendants or the wrongdoers claimed that they should dismiss the case. I'm here ultimately because I just want to know if I have rights protected by the Constitution under the Sixth Amendment to face my accuser. The state is alleging that I owe some form of a debt. I asked the state to provide the proof of claim. If someone, man or woman, would come forward and swear to the genuineness of the debt, I would have no problem paying it. It's in all my paperwork. I've been going over this for 6 years. Since my lawsuit started, I've asked for someone to come forward and just validate the debt. Still to this day, no man or woman has come forward and swore or affirmed that the debt is true. So I'm here today to know certain questions, such as, do I have rights protected under the Sixth Amendment to face my accuser? Also, if no one claims and testify to the truthfulness of the debt, is the debt valid? How can I pay for something if I don't know what I'm paying for? There was never no bill of itemization or bill of particulars. How can I pay for something if I don't know what I'm paying for? How can I pay for something if no man or woman wants to come forward and state their claim? So here it is. There's a debt against me, and I've been arrested multiple times. I've been in prison over 100 and something times over this debt. And still to this day, as we speak, there's no one willing to come forward to validate the debt. So I just want to know, how does all of this work?
Are you finished?
For the most part, sir.
Okay. Representative Fishbone.
Thank you, Mr. Chairman. Morning, sir. Nice to see you. I'm just trying to figure out what kind of debt is this?
In all honesty, it's alleged as child support, but from my understanding of law and I know my rights, I have a right to face my accuser. You guys, the government, the people who took an oath of office, they swore to uphold those rights. So if those rights are not guaranteed, I would just like to know that if I don't have my constitutional rights, as me as a man, as one of the secured people here, because I don't work for the government. I'm supposed to be protected by you guys. As one of the people of the land, are you guys obligated to secure my right to be securing my person, my property? Because a debt is a debt, and all I want to know, I'm willing to pay it. It's not like I'm running from it. If I have a right, I have a right to do interrogatories and ask questions. Throughout the years, none of my information or correspondences have been answered. They just totally railroaded me and just disregarded anything I have to say in regards to this debt. Is either pay the debt or go to jail.
Okay.
And my thing is, why do we have this constitution? Why are they saying we have rights if we're not getting the rights? So I just want to know today or in the near future, do I have rights secured by the Constitution or not? And can you guys, because the claims commissioner couldn't do it, can one of you guys or someone compel the person, the man or woman who's saying that I owe money to come forward and state their claim?
Okay, so it's a child support debt, and when did that debt, or when did some court say that you owed the debt?
I don't know exactly when, but I know that I started to ask questions in 2014, 15, 16. And those are the years that I got arrested the most. Those are the years that they threw me in jail. Those are the years they felt like they didn't have to answer any of my questions. This is all documented. I know
So-
you guys are busy, but I kind of figured you guys wouldn't be too familiar with it. But I have in my claim, everything that I'm saying could be validated. None of my paperwork was ever answered. They just, said, hey, pay this money. Don't give me an itemization of how they got to the number. I have no clue how they got to the number. And they're saying, pay this money or go to jail.
Okay,
And when I asked to see who's the person making the claim, everybody just look in the sky and start scratching their heads. They're not.
Mr. Walker, Mr. Walker, we are happy to have you answer. The representative is trying to ask you a follow-up question now.
I'm sorry about that.
well, thank you, sir. So the debt has existed for about 10 years. And what are you looking to do? I mean, usually these cases come to us because somebody's looking to sue the state of Connecticut for something. So
Yes, I'm suing for forced imprisonment because they arrested me and threw me in jail, and the reason being over a debt. Okay, so there's proof that I was in prison. They're not denying all the times they arrested me and how long they arrested me. So the fact is, I've been arrested. I've been in prison. The other fact is they cannot validate the debt. There is no debt as far as I'm concerned. No one has come forward. If that's the case, anyone could do that. Anyone could just go make a claim and not swear under penalty of perjury. That, from my understanding, court don't work like that. The way court works, whether it's criminal or civil, when someone makes a claim, they have to swear or affirm that that's the truth, the whole truth, and nothing but the truth. Because if that's the case, everybody would be in the courts just making claims without having to testify and stuff. So I know that something's not right. And I know that if this was really real, over the 6 years, for the course of the period that I've been asking, someone would have came forward and said, oh yeah, of course. Here's, let me validate it. Let me put my hand on the Bible. Yes, you owe the money, please pay us. But that has not happened.
So you were incarcerated due to the fact that you didn't pay the child support, and a family support magistrate of some sort ordered you to be held with a purge amount. Is that fair?
No, that's not fair. What you're saying is what happened, but what's fair is that, or what needs to be acknowledged is that this is all a debt. You're putting a name on the debt. It doesn't really matter.
Mr. Walker,
Yes.
let me intercede for a second. I think the representative is trying to establish what happened. So for clarity, for those of us listening to understand the case, I recognize that you don't agree that it should have happened.
Yes.
But we're trying to get clarity. So in answering his questions, if he's suggesting to you that something happened and that's his understanding and it's what happened, it would be helpful if you responded by letting us know that that actually happened, and then potentially going into your story. But if you assert what you feel as opposed to answering the question, it actually muddies our understanding of what happened.
I understand.
Proceed, Representative.
Thank you. And I do apologize, because when I said to you, is that fair? Perhaps that was an unfair, I was just meaning, what I meant by that was, is that a proper what I said is that generally what happened. So it was unfair of me to characterize. So let's go on. And then, so you got picked up, probably on a capias, and they held you on the purge. So now you're looking to sue
They, I'm
the
sorry.
magistrate or judge, right, who issued that order.
So can I just break that down a little bit? So actually it was been 16 times, about 15 to 16 times in a 2-year period. And I think I did a total of 150 something days.
I
Now,
missed
mind you,
my chance. See, I was there.
hello?
Yeah, if you're not testifying, please mute yourself.
All right, so you over a 2-year period, you spent some significant time.
Yes. And the whole time, as you can, as you look at the claim, my paperwork, the whole time I went through the Superior Court, I went through the Appellate Court, I went through the Supreme Court. The whole time I was asking the same thing and no one wanted to answer me. So my rights has been denied as a defendant. Y'all won't answer my interrogatories. Y'all won't treat me like a man. Y'all won't treat me like nothing. Y'all, it's do it your way or go to jail. So that's why I know something is wrong, because everyone has a right to face the accuser and ask questions. How come none of my questions have been answered? How come no one wants to come forward and validate the debt? Something's not right here. If this is all kosher and this is all good, when I go to court, I have to testify and put my hand on the Bible. How come the people on the other side, when I go to court, don't have to put their hand on the Bible? How come they don't have to swear? Something's not right here. And it has caused significant damage and harm in my life and injury. I have phobias. I have problems with the law system, with cops, with everything, and it kind of ruined my life. I wasn't like this before my rights was violated. So something is not right here.
Mr.
Something
Walker,
is not right.
I'm going to advise you again to respond to the question being asked. We get that it has had impact on you. What we are trying to do is discern what actually happened. We weren't part of what happened. And so when the questions are asked, that is for us to get a clearer understanding of what happened.
Okay.
The other parts of it, I will not say are not important, because they are, but the other parts answered out of context do not help us to get to the bottom of what happened here.
Okay.
Thank you, Mr. Chairman. So, sir, what I asked you was whether or not your action that now comes before us is your attempt to sue the judge or magistrate who had you locked up. Is that
right? Because for multiple reasons. One, because they didn't protect my rights secured under the Constitution to let me face my accuser. So multiple times I asked to see the person who's making the claim, the man or woman, or even a sworn affidavit. I have never seen one where someone was swearing that I owed the debt, and it was itemized. It was a bill of particulars stating the amount that I owed and why. And two, because the claims commissioner keeps on insisting that the magistrate has judicial immunity when he does not, because he is not a judicial officer. Under the Connecticut Constitution, for someone to have judicial immunity, they have to be a judge. That on their own information, on their own website, they all acknowledge a magistrate is not a judge. So how does this man have judicial immunity?
Mr. Walker, please allow the questions to be asked.
Okay. No, I'm answering his question just to let him know why I'm responding the way I am.
Walker, I'm just going to suggest this to you again. There are questions being asked, and when the question gets asked, that helps to inform us. And as you have seen, there are follow-up questions. You seem to respond to every question, telling us about your right to face your accuser. We have already noted that. We are aware of that. We're trying to figure out what the breakdown is here. If you keep doing that, and you can, right? But if you keep doing that, you're going to confuse the answer and have impact on how we are able to see your case. I think you want us to have the clearest information possible, so that when this is over and there's an analysis done, that analysis is based on what actually happened. That is the reason that I'm cautioning you to try to be clear and not go too far into everything that's happened in response to every question being asked.
Okay, I'm sorry. I'm just a lot of anxiety. It's been a long time since, you know, this case was filed in 2018. It's been a long time.
Thank you, sir. And you know, I appreciate your patience in trying to explain this stuff to us. So you sort of got me to the next step and halfway through the next question. So is it accurate that the claims commissioner dismissed your claim based upon a level of immunity that the individual and or individuals that you want to sue are protected by?
Yes.
Okay, good. All right, so now I understand why you're before us. And it's your position that a family support magistrate in Connecticut does not have that immunity?
I don't. So I've submitted this paperwork already to you guys. I could pull it back out and reread it, but it went to me, it went a step further past that because I know that and they know that because it's posted on the website that and the Constitution says that a judge, you know, has judicial immunity. The magistrate, he didn't put his oath of office on the record. Every time I asked him, there's no proof to me from what I seen that that man, those men, because it was different magistrates, it was different judges. It's not just one individual. Nobody uh uh um respected my request as to show and prove their oath of office. So how would I know if someone's really in judicial capacity or not? I don't know. From what I know, they weren't because they didn't want to prove it. If they were in judicial immunity or judicial capacity, there shouldn't have been no issue to say, okay, here's a copy of my oath of office. But from what was done to me and what the record shows, I do not believe that they was in judicial capacity when they adjudicated against me. I do not believe that.
Okay, last question. Were you in court each of the times that the orders were issued?
So what do you mean by that?
Were you
What do you
in
mean when I was sent to jail, or what do you mean?
the child support orders?
I couldn't say. I'm not familiar. I don't think I was, sir.
Okay. All right. Thank you, Mr. Chairman.
Thank you, Representative Senator Kissel.
Thank you very much, Chairman Winfield. I just have a couple really quick questions. Do you have children? I mean, did you ever acknowledge that you have children where you have to pay some kind of child support? Or are you saying you don't have any children where you would no way owe any kind of child support?
All right, good question, sir. So I have children, but my children's mothers, besides one, which is the only one who ever took me to child support court. The other ones never took me to child support court, and this is my opinion is it had nothing to do with the money because I have witnesses, family members that state that I tried to pay her money. She was doing stuff out of spite because of my new girlfriend. But for the most part, I only went to child support for one of my kids' mother. Now the thing is, I know my rights. I know my rights as a man that no one could invade my rights to property. The child, the kid is between me and the mother. For my understanding of child support, it has to be consensual. All law is consensual except God's law. You know, I cannot change if I want to hurt someone or if I want to do this, but I understand, have a degree of level and
I don't
contract
want
law.
to be, yeah, I don't want to be rude, but I appreciate where you're coming from on this. I'm not an expert in this area at all, but I believe that if the state assumes a responsibility to help support children, then the state then has a right to seek compensation or funding from.
But what if,
Hold
what
on,
if you
hold
don't,
on,
I'm
hold on.
sorry.
But the nub of your case, I think, is A, getting an explanation as to what took place essentially at the first couple of magistrate hearings. But my last question is this. Are you stating today, this morning, that you never got notice to that first hearing? In other words, are you stating that you feel that these orders were entered without you being provided adequate notice to come to the family support court and adequately represent your own interests?
Absolutely. They spoke for me on the whole time. I never agreed to any of this. So
You
from what
even
you
there?
just
Were
said,
you there?
you said if the state helps you, I forget how you just said that. How'd you just say that?
No,
You said if the,
my question is though, were you served a notice being told there's this claim and you need to go to court, to the Family Support Magistrate Court? Did you go there for a hearing?
you mean for the
Yeah.
initial
The
court or
initial-
the after the days I was getting arrested?
No, not when you're getting arrested, for the initial hearing where this issue was apparently decided.
No, sir.
You notice.
No, sir.
Okay, thank you. Thank you, Mr. Chair.
Thank you, Senator. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, Mr. Walker, thank you very much for joining us this morning. We'll hear next from Lorianne Manilli. Lorianne Manilli.
Hello,
Hello, good morning.
good morning.
Good morning. If you can turn your camera on, if not, just proceed.
I don't know how to do it. What do I have to press something?
I don't know your setup. You may proceed.
Start my video. There we go. I'll try that. Oh, there we go.
That worked.
Thank you. I'm sorry. I'm the most computer illiterate person you'll ever have on your
You did a good job.
courtroom. First of all, thank you very much for allowing me this time. I am, as you know, just requesting that my claim against the state not be dismissed. Kind of a little bit embarrassed because after listening to these other the other testimonies so far this morning, you know, people with injuries and things like that. I didn't have any physical injuries. And obviously I haven't been put in jail and all those other things, but I have been greatly inconvenienced by the claim that I have. Hope they can hear me. Can you hear me?
We hear you.
Oh, okay. I'm sorry, because when I look at my thing, um anyways, my claim is just about negligence on state roads in Connecticut. I've gone to the actual town of London on a couple occasions, explaining to them what was going on, and they came to me and said that it was a state road, so no one would help me, so therefore I ended up going to the state with all this. I had just purchased 4 tires on my car. It was a huge financial burden. I know that comes with being a car owner, but it was a huge burden to get the 4 tires. And unfortunately, for reasons that isn't even relevant to all this, but I was staying up north in Connecticut, and I was on those roads on a regular basis, more than, you know, a normal person would. And I kept getting nails in my tires from the construction. So I've even stopped at the construction site. I kept saying, these nails are ridiculous. I can't afford to keep buying these tires. I submitted proof how many tires I kept going through with nails in them. And I just feel as though it got to the point where I just couldn't afford it anymore. I couldn't even drive my car. And I was calling the offices and saying to them, I can't even use my car. I'm paying large amounts.
Miss
My car payment was $650 a month, and I couldn't even drive my car.
Ms. Manelli.
Uh-huh.
I'm trying to inform you that your time has
Oh,
elapsed.
thank you. Thank you.
You're welcome. And Representative Fishbach.
Thank you. Good morning, Ms. Manilli.
Hi, good morning.
Ms. Manilli, can you just tell me so I can orient myself, where on our agenda your matter appears, if you know?
You mean that HJ 205?
Yeah, is that it? 205?
Yes, sir.
Great, okay, so I got that. Thank you very much for that. So when was this happening that you were driving on the road and, well, I'll leave it at that. When was this?
Approximately 3.5 years ago is when I started driving on those roads. I got one nail, got it fixed, two nails, got it fixed, and then all of a sudden there was so many holes that they said they could not patch it. It would be unsafe, so I had to buy a new tire, and it just kept snowballing. And the next thing you know, they said we can't just replace two tires, you need to replace four. And I'm like, I just got done replacing four tires, and I literally did not have the money to buy four more tires. So I had to park my car and make a $650 car payment every month and not even be able to drive the car.
And when it happened the first time,
Yes.
did you let anybody know?
Absolutely. I kept calling. I spoke with Jennifer in the New London Transportation Department. I kept explaining, I kept stopping at the construction site because I knew that's where it was coming from. Because on one occasion, I actually saw a whole pile of nails on the side of the road. I mean, it wasn't like I was driving on sidewalks. I was driving on the main road, and there just was so many nails because they were doing the construction. But yes, it was approximately 3.5 to 4 years ago. And yes, I did call the office, but unfortunately they kept saying that it wasn't a New London issue, it was a state. So then I started calling the state,
Who'd you
and they
call?
kept saying, we're doing construction. What do you want us to do? But the construction was going on for years. It wasn't like it was just 1 week. And they even told me to take different roads, but I wasn't from there. I lived my whole entire life in Monroe, Connecticut. So being up in New London for that year, I have no idea any other roads. Like, it wasn't like I could, if you put in GPS, it brought me back to the same roads again. I wasn't familiar with that area. So I always had to travel on those roads.
And who did you call at the state?
The transport, trying to read my thing here, transportation department. I dealt with, let me get, if you want names. It was, I mean, this is a long time ago. I know a lot of these people aren't even there anymore. All the people that I dealt with through this whole thing was Anthony Fablietti, let's see, Attorney General's office, Governor's office, Grant Commissioners, let's see, Tara DuPont, Anthony Holland, Erica, Carlos Wimberly. I mean, all these are all different people. Andrew Morrell, Anthony Holland. These are all people that I talked to one time or another.
Okay, so you didn't just leave them voicemails, you actually talked to them.
Oh, every single one of those people at one time or another, either I talked or emailed something.
And what did they tell you? That seems like a lot of call.
Oh, I did this for a long time because, like I said, my car was parked and I was making a $650 car payment and couldn't use my car.
Got it. What do they
Every time I contacted someone, it was always the same thing. What do you want us to do? It's construction. You just have to wait for the construction to be over. You take a different road. And I'd say to them, one of the restaurants that I used to pick up food from was, now I forgot the name of the restaurant. It's two initials, but it's right there on the corner of the road that I kept having the issue with. I had no choice but to enter that road. So they kept saying, use a different road, but there's no way you can use a different road. That's where the restaurant was on.
Okay, so then then you finally put in a claim with the claims commissioner for 4 tires. Is that? Did they have a hearing on your case?
I don't know if it was an actual hearing. I received a letter that said it was denied, that they weren't gonna pay me for the tires. So I got something that said it was denied. And yes, I appealed it, and then I received something that said, they were gonna dismiss it, that it was being dismissed. And then they asked me, that's why I'm here, because I'm asking for it to not be dismissed.
Okay, what was the basis for the dismissal, if you recall?
Do you know? The notice of claim. I'm not even sure. I'll be honest with you, sir. I'm not really sure. I'm looking at what do you call that? It's like the court document. And it doesn't really say the actual, it talks about the background and all that, but it doesn't really say, talks about the motion to dismiss. I
Okay,
do know for a while they were saying that it wasn't the state's fault, but obviously it's a state road.
so the AG's office filed a motion to dismiss.
Yes, sir.
Ultimately, that motion was granted. And
Yes,
that's
sir.
here today. So I'm just trying to give you an opportunity because, what's before us here today is, why the decision to grant the motion to dismiss was wrong. So I'm just trying to
Well, it's obviously it's liability. It's all liability. They're saying that it's not a state problem. So like, why would you request monies from the state when it's not their fault? But the road that it was happening on is a state road.
Okay, thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? Representative Porter.
Thank you, Mr. Chair, and thank you for your testimony today. I'm just curious as to what was the total amount that was expended on tires out of pocket for you, through you, Mr. Chair.
It was $1,124.
And is that the amount of the claim?
Yes, and I'm not even counting time missed of work. I'm not counting any extra things. All I asked is for them to replace the tires that were damaged due to their negligence. That's it. Nothing extra.
All right. Thank you so much. Thank you, Mr. Chair.
Thank you, Representative. Senator Kissel.
Thank you very much, Chairman Winfield. I just want to thank you for coming and testifying on your claim. Even if you were a powerhouse attorney here in Connecticut, that's a difficult case to try to prove. First of all, yeah, I understand the mix-up regarding town-owned property, state-owned property. Once you establish that, though, it's more than just, coincidence. And a lot of times we very naturally will say, well, I was in such a spot and I saw such and such stuff, and then my vehicle was injured by these things. Therefore, it's the state's fault. But the burden of proof on a civil matter like this is on you. And also when you're making the allegation that but for these nails, my tires would have been okay. That's a difficult case to prove. So I think you've done the very best you can, but it's a difficult case. And the standard is not that every parcel of property that the state owns, that if anybody gets injured there, it's automatically the state's fault. If that's just not it, we'd all be bankrupt long ago if that was the case.
I went through 13 tires, sir. I'm not charging for 13.
I am not
So
saying
you were just saying that you can't always blame the state. And I agree with you. I absolutely agree with what
No,
you're
I'm
saying.
extremely sympathetic. My son just went through the same, like, not the same, but he's had bad luck with potholes. The other night that he had a tow truck have to bring him home. They couldn't even get the old flat tire off to get the spare on to then
Mhm.
to go to the garage. So you had to get a tow to the garage afterwards. And then because you want all the tires to be the same, you have to change all four, and it's expensive. Trust me, I get it. And the odds of this happening to you and that it isn't the cause of the nails, I get it. But
Well, you also mentioned, I also want to tell you,
the claims commissioner.
I also wanted to mention to you, I drove 203,000 miles in 2.5 years. So up and down that road that's what I'm trying to say to you. Most people don't even do that in the lifetime of a car. I did that in two and a half in 2.5 years. So that's why I'm able to say to you, that's why I pinpointed it there, not only because that's where all the construction was, but because of the fact that I witnessed on a couple occasions, I witnessed the nails in the road. So I even kept a couple of the nails to show, well, this is the one that they pulled out, and this is the one that these are the ones they're using in the road. So I know you're saying it's hard to prove something, and you're absolutely right. This wouldn't have been going on 4 years, but it's that was the road I traveled on majority of the time. That was the road that was having all the construction. That was the road that I witnessed majority of the nails. I've gotten out of the car with flat tires, and I just seen nails in the road. And I've gone to these people and said, stop leaving them in the road. And of course they're saying, well, we can't do that. We're working,
Ms. Minelli, as with the prior person testifying, I just want you to understand that we are trying to get clarity. And I think what Senator Kissel is trying to do is suggest to you that he actually understands. He's not questioning put forward. So I don't want you to feel like the committee is questioning whether you had the experience you had or not. I think he's actually trying to, in some senses, commiserate with you.
Yeah.
That's sweet. Thank you.
So I'm very careful about how people walk away from this experience, and I get how you might feel something different from whatever.
Well, it's just been hard because it has been, 3.5 years, and I actually went 2 of the years and wasn't even able to drive the car. I had to leave it parked.
So we're going to let Senator Kissel.
Thank you.
Chairman Winfield is exactly correct. I mean, I understand what it's like to live paycheck to paycheck, and that car tires are really expensive. And especially if you have to replace all four and you weren't budgeting for that. I get it. Unfortunately, in this process, we are not an appellate court. That's not what we serve as. We're just elected officials, and we do the best we can on this committee. But our job is to sort of look at all of these claims and say, is there anything so violative of due process or the Constitution or just simple human dignity in the procedure that we feel either it A, should go back to the claims commissioner for a rehearing or reinvestigation or something like that. Sometimes people are looking to be able to bring a whole new matter, but in the superior court system, we actually have an ability to order the enforcement of certain awards, but typically we do not go back and retry the case. And so I understand how this whole weight of evidence tends to be on your side, but there are also arguments that I could see that would be on the other side as well. And these are you're putting forward that, in your sort of ability to make your own case. But when you say, hey, 200,000 miles, I could say that you got a lot of wear and tear out of those tires. You could say, hey, I saw this stuff happening on the side of the road. I went past that all the time. I could say, on the other side of that equation, you keep going back to the same place. I get it. It was the only place that you knew how to drive. I get all that. I really, Chairman Winfield is correct. I do commiserate with you. I think you've done an excellent job in presenting your side of the story. And I just wanted to say thank you for coming and testifying. But I
Thank
just
you.
want everybody, whether it's on Zoom or in the room or out there watching on CTN, just because something happens on state property doesn't make the state automatically liable. Thank you. Thank you, Mr. Chair.
Thank
Keep
you.
in mind though, sir, that 200,000 miles wasn't, I bought additional tires, which I had no problem buying tires, especially wear and tear tires. I could show you a
Okay,
stack,
Ms.
a
Mendez,
stack of receipts for
Ms. Mendez.
tires.
um, we understand that you have things you would like to show us. We also have access to what you have, what's been presented. So
Right. Thank you. Thank you, sir.
Yes, absolutely. And let me just check, are there comments or questions from other members of the committee? Comments or questions from other members of the committee? If not, thank you very much, and thank you for doing such a good job this morning. We will next hear from Clarence Austin. When you sit down, make sure your microphone is on, and you will have your 3 minutes.
Are you ready for me now?
You may
Yes.
proceed.
There was an article in the Connecticut Post about Northern Correctional Institution. It came out in 3/20/21, and I filed a claim, that spoke of some of the abuse that happened in that institution. Where it says torture, blah, blah, blah. And they spoke of some of the abuse. And the reason I was put in that prison, because I was in a local jail, and while in the medical unit, they didn't give me my medication for my seizures and blackouts, and ended up busting my head. I had to get 18 stitches. So when I came back from the outside hospital, the nurse comes in with 4 COs. They hold me down, pull my pants down, give me a shot in my behind, and I wake up in Northern. 4 pointed to a stainless steel bed naked. Then when I go to court for the charge I'm arrested for, they have charges of me assaulting correctional officers. 4 correctional officers. So the court-appointed lawyer says, Mr. Austin, they could just come up to me, Mr. Austin, if you don't take this, you can get up to 27 years. I said, I'm not copping out of nothing I didn't do. I said, I didn't, they called the police then. They call police now. I said, I didn't assault no police officers. I said, you got my file mixed up with somebody else's. She said, well, it's up to you. If you don't take this, you get 27 years. So she started walking away. So I called her back. And I took the 3-4 year sentence under concurrent. But see, before then, for years, I've been assaulted by correctional officers in the prison system. See, I even wrote a book about it. It's called Power Tripping Leads to No Justice, Only Just Us. And see, I'm suffering mentally from that. Mentally, from my dreams. And I know I got CTE because I'm trying to get tests done, but they say you can't do that till you die. And I've seen a psychiatrist for years because, give me medication that keeps me calm. I stopped doing a lot of street drugs I was doing. And I just want to read you this introduction of this. And I want everybody to take this very seriously. But I'm not a racist, but I am prejudiced. I'm prejudiced against any human being or animal on this planet that does not show and give me care and respect. Oh, y'all got me shaking and nervous. There has to be equal law for all people, not just one group or race. When the crime happens in suburban areas to Caucasian, the crime gets full news coverage forever and fully investigated by the police. That's one of the reasons why people will not work with police in the poor minority neighborhoods, especially when crimes happens to an African American. Caucasians get police protection, minorities don't. From all crimes of any kind, from assault to murder. For Caucasians, it's a tragedy, but to a minority of a poor neighborhood, they treat it like eating a meal at a fast food restaurant. They look into the crimes of minorities, mainly African Americans, like people going shopping. They didn't find what they want, so they buy something else. My story is about an African American male, me, who went to prison for crimes I committed. But when I tried to get help for crimes committed against me, no justice was given. You have to forgive me, I get excited sometimes. While I was having grand mal seizures in the Department of Correctional Custody, I was brutally assaulted and beaten by correctional officers while fighting death. My sickness was worsened. My sickness was worsened from the beatings I took while having grand mal seizures.
Mr.
Yeah.
Austin, I don't know if you heard,
Yeah, okay.
but the bell has rung. So I'm gonna, I assume there's probably a question for you, but what exactly is your claim for?
My claim is for Northern, because I put in the claim when I see this article in the paper about the abuse, and like I said, it only speaks of some of the abuse that was in that prison. I was kidnapped from the local jail and sent to this prison just to cover up a crime of medical negligence when I bust my head and had to receive 18 stitches.
So it's related to that particular incident.
Right. And so I've been trying to seek justice for the crimes that was committed against me for years since 1993. And when this article came in the paper, I filed it the same year that the program was shut down because they spoke of the abuse that was in this prison. But like I said, only spoke of some of it,
And
not all of it.
Can I just ask you this question? So what year was that article?
320.
Okay.
320, March 2nd, 2020.
Okay. And just for my information, when did the incident actually happen?
This happened in 1995.
The incident that you're referring to?
Yes. But see now, when I explained to them, I said my case should be in the same legal category as the priests who were violating young boys' civil rights in Boston in 2001. The same as the Olympic coach whose civil rights violating young people's civil rights. Bill Cosby, any other case like that where a person's civil rights been violated. I mean, because mine were seriously violated mentally, physically, and legally.
Okay. All right. What is there a comment or question from members of the committee? Comment or question from members of the committee, Representative Porter?
Thank you, Mr. Chair. How much is your claim for?
I put in 4 million, $1 million for each year I was up in that up in Northern, because like I said, Northern has 3 phases, they wouldn't, from what the employees did to me, I couldn't go on. They kept me in phase 1, 24-hour lockup, 24-hour lockup all day.
Okay.
Sometimes
I understand that. I know about the phases and how you can go forward and then bounce back to where you started. What years are we looking at? You said
from 1995 to 1999. I mean, I have the medical records, incident. I mean, because I filed a claim for incident report, and when they handcuffed me, I still got a scar here while I was having a grand mal seizure. When I went back to prison after 10 years, they sent me straight back to Northern. I said, I've been out of prison 10 years. I said, Mr. You know why you're here? I said, yeah. I said, no, why I'm here? He said, because you never finished the program. I said, I've been out of prison 10 years. Don't that say something?
Okay.
I mean, 10 years, I said, then they sent me straight back there. The same thing for years. Okay, like I said in my book, it wasn't the people in prison I had to worry about. It was the employees.
Right.
who were
Well,
committing-
I got clarity to the questions that I needed, and I'm not sure if anyone else has questions for you, so I don't want to
Oh,
belabor
I
the issue.
apologize.
But I do appreciate you coming in today to defend your claim. Thank you, Mr. Chair.
Thank you, Representative. Representative Fishbond.
Thank you, Mr. Chairman. Good morning, Clarence.
How you doing?
Thank you for coming here. I'm doing pretty good for Friday. I just wanted, so you want to bring a claim against the state for an incident that happened in 1995 is what you said, right?
Yes.
And I'm just trying to, because we've heard about other claims and how long they've taken to dispose of. When did you file a claim with the Claims Commission?
Well, I've been filing claims in states courts, federal courts, but from the lack of not being able to get legal assistance, from the lack of not having money to file when I had money to file for federal court. I mean, and like I said, when this article came out here, about Northern, it was written by Yale Law School, and March 2nd, 2020. As soon as the program shut down because they spoke of this abuse. In 2021, I filed my claim that same year. They say you have a year to file for a claim. So I filed my claim for that. That same year, the program shut down when they spoke of the abuse in this prison.
Okay, so just to be clear, just because, this is your opportunity. An incident that happened in 1995, you first filed a claim in 2020 regarding that 1995 incident, right?
No.
Okay, so I'm trying to figure this out.
Okay. First of all, let's try to say something there. See, when you're in this prison, you're in phase 1. They got control of everything you say and do. Anything I was kidnapped and put in that prison because I bust my head in the medical unit and had to get 18 stitches in my head. So when I come back from the outside hospital, the nurse holds me down with force, comes in with 4 shields, they hold me down, put my pants down, give me a shot in my behind, and I wake up in this prison. Then I go to court for charges. I filed, when I was up in this prison, I filed in Bridgeport Court to have the charges dropped.
Yeah, I'm just trying to figure out the timing here, sir. So, you know, let me just be more open with you, because I think what's before us is the claims commissioner is probably saying that by the time you filed your claim, that statute of limitations, that the time period had run.
All right.
Is that accurate?
That's what they saying, but
Okay,
what I'm
so-
saying is this here is my evidence when it speaks of the abuse.
I
And they shut the
understand.
program down because of that abuse. So that I filed my claim when they shut the program down in 2021. I filed my claim that same year. So I should be able to seek justice from this, from this, because this is they spoke of some of the abuse in this prison. They didn't speak of all the abuse. I mean, I've seen people die in there from outright negligence.
Okay, so I'm just looking at this, you know, I don't want to, I take it that you're not a lawyer, that, you know something about the law. Obviously, we wouldn't be here today if you didn't. But, you know, in my experience, that time period is extremely difficult to attack, right? So, and I'm not aware of a case like yours where that long period of time was ignored. So I just wanted to give you an opportunity to, you know, perhaps educate me, educate us.
Okay, you know why I was ignored? For the simple fact, like I said, when you file complaints and claims in this prison, they have control of everything you say and do. Everything you say and do. They control your mail, they control your visits, they control everything. You can't even look out the window. I looked out my window. They said, "What you doing by your window?" I said, "I'm looking out the window." "So you can't look out the window." I said, "Why not? You got the window here. I'm looking out the window." I mean, how can you file complaints with a legal system that controls everything? I mean, they let go out what they want to go out and let come in who they want to come in, let you do what you want, let like I said, I was kidnapped and put in this prison
So
to
let's,
cover up a crime of medical negligence.
can we unpack that a little bit? And we're working on this together, right? Because I'm certainly sympathetic to your situation. Are you saying that in 1995, 1996, you did not have the,
1995, 99 to 1999, 4 years I was locked
Okay,
up in the
just
prison,
listen,
24 hours
just-
locked up.
just try and stay with me a little bit here, okay? 1995 is when you say the incident happened.
Yes,
You have a year to file the claim, right? So we're gonna talk about that period. And are you telling us that you did not have the ability to file a claim during that period of time?
it's what these people want you. They have when you're in phase one, they have control of anything and everything you say and do. If they don't want mail to go out, it's not going out. If they don't want you to have a visit, they're not letting you have a visit. I had my mother called up there and asked me, I want to know how my son is. You know, they tell my mother, "Oh, your son's a grown man, don't worry about him." Because she just worried about my sickness. I mean, that's because they used to beat me down in the past when I was having seizures. I mean, like I said, I mean,
Well, let me just,
it
let me-
just,
let me just explain to you where I'm at, right? So I could see if, you know, in 1995, solitary confinement was utilized frequently in our penal system, right? So somebody was in solitary, you know, basically for the period of time that it would have been required for them to do the claim. And that's what I'm hearing today. You know, I'm going to look at that case a little bit differently, right? So, you know, that's sort of what I'm wrestling with. I mean, the claims commissioner said period of time. I mean, we're talking about 16 years here, right?
yeah, you know
So-
what? I've been fighting sanity for over 25, trying to seek justice for over 25 years, trying to get justice for what's been happening to me for crimes I committed while in Connecticut's Department of Correction custody. I mean, I just had grandma's seizures and they beat me down. And then I started having blackouts.
No, I appreciate you
I
coming
mean,
here today.
see, the point is, why is it so hard for the state to admit when your employer is wrong. I mean, like I say, my case should be in the same legal category as the priest, the Olympic coach, Bill Cosby, and anybody else whose civil rights been violated for decades and years. And mine was violated physically, mentally, financially. I mean, and I'm fighting sanity now. If I've been trying to get tests for the CTE, and my therapist gives me medication just to keep me calm, which I take some when I come here.
No, I appreciate
So
you
you
coming
do-
here today. I don't have
I
any.
mean, I don't understand what was not to understand. I mean, I had crimes committed against me. My civil rights were violated, mentally, physically, financially, and it still will be violated until the day I die. I mean, I have dreams where I have dreams that haunt me. When I wake up from the dream, I got the scars on my body and face and mind. I mean, scars on my face and body that remind me of what happened to me while I was in this prison and in the other prisons. I mean, 24-hour lockup. They handcuff you to your bed, leg cuff you to your bed. If I have a seizure or blackout, I wake up, I'm handcuffed to my bed naked. For what? What did I do? Because they didn't give me my medication? For what reason? What's the purpose? I mean, they say you go to prison supposed to be for rehabilitation. To me, it's for racial recreation. That's the way I took it, racial recreation, for the simple fact. And to cover up a crime of medical negligence. Medical negligence. I was kidnapped from this jail. I mean, from the local jail, because I bust my head in the medical unit because they didn't want to, because they denied me my seizure medication for my seizures and blackouts. There was no need. I mean, like I say, the employees, it wasn't the people in prison I had to worry about, it was the employees.
All right, Mr. Austin. I think Rep. Fishbone is finished. Let me ask you, don't leave yet. Let me just ask you this one question so I'm clear on it on a timeline before us. So the Representative Fishbone was asking you about the claim that's actually before us. We recognize that you're suggesting to us that other things happen, but on the claim before us, that's related to your time in Northern, that while you were there were things that barred you, the way the prison functioned. I'll just put that there. When did you leave Northern?
8/27/99. And you know what? On my release date, they wake me up in the morning and say, Mr. Austin, come on. I had it because I filed for the charge to be dropped against me for me assaulting the COs in the Bridgeport court. They said, you have a court date on this date. I said, well,
Okay.
hold on. My fiance
Okay.
come to pick me up. They took me to court. And
As I've said to other people, I know there's a lot there, and it's all important, but trying to just understand.
8/27/99.
Okay. And the question has to be asked, since 99, the things that you were talking about the way that Northern functioned, were not a bar to you filing a claim suggesting that some wrong had happened in the way that it had been because you weren't in Northern, right? You were in a different facility or you were out. So in those interceding years, why hadn't you filed the claim
I filed claims with state court, federal court
on that incident?
on this, on all incidents. All incidents.
And-
This incident was a
okay.
blessing.
Okay.
This was sent to me by the high power sentences in the paper.
Trying to get clear on what happened, and all of those were disposed of in some way.
By me not being able to get proper legal assistance,
Mhm.
not having the money to do it, for when I went to federal court to pay the fees.
Mhm.
I mean, and like I say, why is it so hard for the legal system to admit when your employees commit a crime?
Sir, we're not going to give you a good answer to that. We're just trying to discern what happened here, why you operated in the way you did, and whether or not there's some relief or no relief that we could provide to you. So that's why I'm asking those questions. That's why we're trying to make sure we understand what happened in terms of the timeline and what happened in terms of how you function. All right. So comment or question from other members of the committee. Comment or question. Seeing none, Mr. Austin, thank you for joining us and providing us with your testimony. Joseph Bernardo.
So you're going to send me some paper stating that nothing that I.
What, sir, I don't know, sir, I don't know how this would turn out. We will have a point at which there is an analysis of all that's come before us, and you will be made aware of that. Joseph Bernardo.
Here,
All right, you may testify.
I just want to say, first off, I feel for that man. I don't know his exact situation, but I've lived through a lot of the horrors that he's talking about. I want to start by reading Bridgeport Correctional Center's mission statement. The Bridgeport Correctional Center shall protect the public, protect staff, and provide safe, secure, and humane supervision of offenders with opportunities that support restitution and rehabilitation by providing meaningful programming designed to support successful community reintegration. Now, I respect Commissioner Shea. I think he provided an opportunity for me to speak, and I appreciate that. But I also think that Commissioner Shea's hands are tied. He denied this claim, which brought it to your attention, because if he were to give financial compensation to an inmate whose complaint is that Bridgeport Correctional Department of Corrections was woefully inept in protecting the inmates and the staff from COVID-19, he would open the floodgates. Everyone would be bringing a suit against Department of Corrections. The fact still remains. The Department of Corrections of Connecticut was negligent in protecting the inmates and the staff, but I'm here to speak on my own behalf. The time that I spent in there in a room that's maybe 50 feet wide by 60 feet long housed 50 men, and that didn't change for years. I started my incarceration in early 2019. COVID didn't show up until 2020. I got sick in March of 2020. The documentation should be somewhere, hopefully within your grasp. The 4 years that I spent incarcerated, I was contaminated. I suffered through Alpha, Delta, Omicron. Go through all the variants of COVID-19 that was coming through the jail. You could tell at night, you would always hear someone on the other end of the room already starting with their coughing. You knew that was going to make its way to you. The answer for Department of Corrections was continual lockdown. They wouldn't even let us go outside. They kept us on our bunks. They would feed us on our bunks. The only time you got up was when you went to the bathroom. You had to take shifts to take showers. We had 4 showers, 4 sinks, 2 toilets for 50 men. The same sink that you get the drinking water to fill the hot pot or you brush your teeth in is the same sink they're washing underwear in. It's the same sink people are spitting blood into when they brush their teeth.
Mr. Bernardo, your time has elapsed, but I'm not clear what exactly the claim is. So I know you have a lot to tell us, but can you state what the claim actually is?
My claim is against the Department of Corrections for infecting me with the COVID-19 disease that has affected me and continues to affect me to this day and will have future negative effects on my health as I age.
Okay. Questions from members of the committee. Representative Fishbone.
Thank you, Mr. Chairman. And I take it that after the hearing that your claim was dismissed.
Commissioner Shea stated the reason being that the Department of Corrections did the best they could under the situation of it being a pandemic. With all due respect, that's ridiculous. To this day, they still haven't changed the fact that men spit in the same sink that you drink out of and you brush your teeth in, they're washing underwear. They couldn't control foot fungus in the showers, yet they're going to control a national pandemic. They saw this coming and they did nothing. Their answer was to double down and keep us together. I sit on a bunk and I can touch 7 different men within arm's reach while sitting on my bunk. That's how close we are.
Okay, and just for the record, in our agenda, I think your item is item number 66, which is Joint Resolution 199. Do you concur?
I can't speak to that. I don't know where that number is. I haven't been given any information as far as where it sits on your agenda.
Okay, that's fine. I only see your name appearing once on our agenda, so I'm gonna assume as we move forward that that's your case. Did you go through, I believe there's administrative levels that you perhaps would go through DOC.
Absolutely. When I met with Commissioner Shea, they had a representative of the Department of Corrections there. We went through all that and they saw my paperwork. They saw everything that I did submit, which luckily got me before Commissioner Shea, which kind of shocked me that they actually finally got some kind of resolution, at least to that degree, before he denied the claim.
And it's your position that DOC should have done something different to prevent your injury?
It's my position that DOC was exceedingly negligent. There was a case brought against Ned Lamont for the negligence of the Department of Correction, which was settled. I opted out of that case. We were informed that they were bringing a case against the Department of Corrections for being negligent for the response to the pandemic. I opted out of that because I wanted to have my own opportunity to express what was going on in that facility.
And that lawsuit was brought on behalf of individuals who had deceased, or
I believe, if I'm not mistaken, Trey McPherson et al.
okay.
I have no idea what happened in that case. I just made sure that I was opted out because I wanted to be able to bring my own case against the Department of Corrections.
Okay, so in the course of your incarceration, you got COVID-19, and how long did you test positive for?
I was infected with that disease on 4 separate occasions,
Okay.
almost every 4 months. As the new variants rolled through, there's no way to not get infected. You're surrounded by men all the time. And like I said, their response was to double down on keeping you from moving. You were in a perpetual lockdown. Lockdown is punishment. When there's a dangerous situation, there's a fight, something, they lock you down, they don't want movement. Well, when there's a disease, they chose the lockdown as their answer. Yet the COs are still going to McDonald's and Dunkin' Donuts and showing up inside your dorm. They're not on lockdown.
So
they're bringing the infection into your dorm, and there's nothing you can do about it.
So I'm just trying to figure out, at least in your opinion, what should have been done differently to prevent you from getting COVID-19. I think what I'm hearing is that nobody should have been on lockdown at all, and everybody should have been commingling. Because I guess
that's not what I'm saying. I'm letting you know what their decisions were. I can only tell you what they decided to do, and that it was very ineffective. It was negligent. Now it's not I don't have the ability to tell you what DOC should have done. I'm sure there's a lot smarter people than I am that would be able to answer that question if they look into it. But I can tell you what they shouldn't have done, which is what they did.
Okay.
They made it worse.
Thank you. Thank you, Mr. Chairman.
Thank you. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, thank you very much for joining us this morning.
Thank you for hearing what I have to say.
Yolanda Ortiz.
Hello.
Good morning.
Good morning. So just let me know when to start.
You may start.
Okay. So pursuant to Connecticut General Statute 4-148 subsection 2 makes an express finding that the authorization is supported by compelling equitable circumstances that will serve a public purpose, as in this instance. My name is Yolanda Ortiz, and I'm here on behalf of my son, Keon Huff Jr. Keon was murdered in Hartford, Connecticut on 393 Garden Street in someone's back hallway. I would like to ask the Judiciary Committee to review the circumstances that resulted in my pursuit of a claim against the state of Connecticut in lieu of the Department of Children and Families. For many years, I've been a victim of DCF. I've had about 10 to 13 calls made on me to DCF, all calls having no evidence of neglect or abuse being found. I thought that Keon would get the proper help that he needed from DCF, only to be slapped in the face with them failing Keon. I do know that in determining custody arrangements, the number one factor that the courts must consider is the child's best interest. Section 17A-2 of the Connecticut General Statutes, DCF is an excellent agency that provides child protection, behavioral health, juvenile justice, and prevention services. But where was the protection when I made the call to DCF the day prior to Keon being gunned down? Me begging the DCF worker to please get Keon because I'm scared that my child would be murdered, only to be told that they will not institutionalize him. I have always felt that DCF was against me. Even when my parental rights were stripped from me without due process, I still showed signs of reunification with me and Keon. When I found out later on that the courts were giving my mom foster guardianship of Keon, with DCF being the sole provider, I wrote a letter to the judge begging him not to give Keon to my mom because she couldn't handle him. DCF went against what I, as his mother, as his sole provider for years, decided to give Keon to my mom anyways. DCF would give Keon to anyone who would act like they wanted him. I didn't even know that DCF placed Keon with foster parents until one day his worker at the time asked me, can I sign for Keon's passport so that his military foster dad can take him somewhere out of the country? I immediately said no, I would not agree. That just goes to show that DCF picks and chooses when they wanted me to be a part of Keon's life. Scratching me from his life is why we are here today. DCF has played a big role in my son's death. I always knew that DCF would be the cause of Keon's demise when they stripped my rights as his mother. The DCF system is broken and needs to be fixed. If the system isn't fixed fast, there will be more Keons in the world and more mothers going through the pain that I'm going through. This pain that I live every day, there's no greater pain. They say that time heals, but it doesn't. It just teaches us how to move on without the person that we love. I also have a person must present a claim to the commissioner within 1 year after it accrues. By law, a claim accrues on the date the damage or injury is sustained or discovered, or in the exercise of reasonable care should have been discovered. But no claim can be.
Ms. Ortiz.
I'm sorry. Yes.
Let's see if there are questions.
Yes.
Your time elapsed.
Okay.
Representative
Thank
Fish.
Thank you, Mr. Chairman. Ms. Ortiz, can you just finish your thought with regard to the 1 year thing?
Yes, sir. So I was saying a person must present a claim to the commissioner within 1 year after it accrues. By law, a claim accrues on the date the damage or injury is sustained or discovered, or in the exercise of reasonable care should have been discovered. But no claim can be presented more than 3 years from the date of the act or event that is the basis of the complaint. The General Assembly may, through special acts, authorize a person to present a claim after the time limit passes if it, 1, deems authorization to be just and equitable, and 2, makes an express finding that the authorization is supported by compelling equitable circumstances that will serve a public.
Okay, so I'm just trying to you were reading from the statute. When did Keon pass?
Keon was murdered March 17, 2017.
Okay, and when did you put in the claim?
I believe it was November 2019.
Okay, and ultimately was your claim dismissed because of it was outside of the time period?
Yes, sir.
Okay. And is there a portion of the language that you were just reading to us that you wanted us to consider in perhaps giving you an exemption from that time period?
Yes, sir.
Which particular clause?
finding that the authorization is supported by compelling equitable circumstances that will serve a purpose to the public and in this particular event.
Okay, and I appreciate that. You're doing really good. You know,
Thank
I have, no problem. You're talking Garden Street in Hartford, right?
Yes, sir.
So I happened to be there last weekend.
Don't make me cry. Please don't.
No, well, I'm gonna tell you, when I was right around the corner on Garden Street, there's two cemeteries there, right?
Mhm. Yes, sir.
And one, when you're driving, I think, westerly is quite old. You can see that, there's been floods and stuff like that, and there's not a lot of color in that cemetery. And the one on the right-hand side, I was amazed at how many balloons and flowers were there. And what that said to me as I was driving through the neighborhood is that's a lot of people that you've lost, lately. Because that older cemetery, there's not people around to really, to celebrate and to remember. But that other cemetery was so full of color. And I was amazed by that. And anyway, what we're dealing with here today is whether or not there's causal relationship between the actions of DCF leading to a third party shooting Keon, right?
Yes, sir.
So is it your position that Keon, what should DCF have been done differently? Let's start with that.
Okay, so there were many occasions where Keon would run away from like Keon was actually placed in different group homes, like the Bristol Star House in Bristol, I believe Greenhouse, the Village for Children's and Families, and Yukon up there in Source, Connecticut. The day before, so let me back up a little bit. DCF on plenty occasions called me, and I don't live in Connecticut. I moved down south. They would call me when Keon run away and ask me, did I see Keon? And I'm like, no, like, isn't he supposed to be in the group home? With that being said, the day before Keon was murdered, I called his worker, and something just came into me where I called his worker, his worker, I explained to his worker that I'm scared for my son's life. I feel like my son is going to be hurt. I feel like he's going to be killed. And he told me that he's not going to institutionalize my son. I feel like DCF has stripped my rights away without due process. They didn't give me a voice. At some point throughout the DCF process, they just cut me off, even though I was doing everything that I needed to do as a mother to get the proper help for my child. Even with me sending the judge a letter begging him not to let Keon go with my mom because she's getting older. I know my child. I know that she's not going to be able to handle him. I think that they dropped the ball. They just didn't listen to nothing I said. And I feel like, when me and the worker had a conversation on March 16th, he explained to me that Keon had a warrant out for his arrest in Newington, Connecticut. I said, perfect. He's at my mom's house right now. Go and get him. I know that Newington would have to get a police escort from Hartford or however that goes. So I'm like, okay, he's there right now. Go and get him. And I do believe that if they would have gotten my son on March 16th, when they told me that he had a warrant for his arrest, my child will probably be here today. I do believe that he would be here today.
No, you are reminding me of a woman in Waterbury a couple of years ago whose son had been arrested. I think he was 17. He was put on an ankle bracelet. And about 6 months later, they went back to court, and the issue was whether or not the ankle bracelet should be taken off of the young man. And the public defender was arguing, doesn't need the ankle bracelet, he's not going to do anything. And the one who was yelling, don't take that ankle bracelet off my son, was the mom.
I already know.
Yeah. And the ankle bracelet came off. And about 2 weeks later, they found his body. It was dumped in Hamden.
Mhm. Because we know, we feel it.
Man,
We know.
I got a call from a mom who lives in Hartford about 3 months ago. And she was like, my kid's running away. What can I do? I don't want him to get arrested. I don't want him to die. They've taken away all these programs. Middletown doesn't exist anymore. But I don't want my kid to die. I hope that child is still alive. I'm just like so concerned about these kids.
Mm-hmm.
Moms know best, right? I mean, I
Mm-hmm.
got in a lot of trouble as a kid too.
I'm sure.
And I could tell you stories. Um, well, thank you for
And
coming.
just, oh wait, and just to thank you for having me. And just to let you know, Garden Street is actually one of the streets in Hartford who have the most killings on that street, Garden Street alone in Hartford, Connecticut.
I know, and I will tell you, I haven't driven through areas like that in years.
Mhm.
And I really felt for the community. But thank you for coming here today.
Thank you for having me.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? If not, thank you for joining us this morning.
Thank you so much. I appreciate you guys.
Next, we'll hear from Attorney Alexander Torbis.
Good morning, Judiciary Committee. Thank you so much for having this hearing today. It's very difficult cases that come to you. The buck stops here. We're here today on Senate SJ number 164 regarding Luis Ortiz's claim against the state. The resolution currently would approve the award of the commissioner awarding $6,000 to my client, Luis Ortiz. And we are asking the General Assembly, pursuant to Connecticut General Statutes 4-159B2, to modify that decision and increase the amount of the award to Mr. Ortiz. So Mr. Ortiz's claim, which was presented by Timely, concerns a work injury at McDougall Correctional in August 28, 2019. He was asked to lift a very heavy vacuum with another worker who was an employee. They fell. The heavy vacuum fell on Mr. Ortiz. He's had back problems since. He's a man in his 30s who now requires a cane to walk, and he's a man who needs to use his body. Given his criminal record, he doesn't get a lot of desk jobs and things like that very easily. He needs to, work, but it's difficult for him because of this injury. Commissioner Shea, who I strongly believe is a great commissioner and does a great job and works extremely hard, found negligence by the state. And normally a worker who's working doesn't need to show negligence to get compensation. But obviously our inmates, when they're working, they're not covered by workers' compensation when they're making $1 an hour in our prison system. So I think it would be fair, equitable, and just to up the award a little bit, give Mr. Ortiz $15,000 rather than the $6,000 awarded by the commissioner. And I will state for the record that I will be undertaking this engagement completely pro bono. I think that Mr. Ortiz deserves a little bit more money for the injury he suffered while working for very little pay in our prison. Thank you.
Thank you. Comment or question from members of the committee? Comment or question? I guess I'll just ask you the increase. How did you figure that increase?
Well, this is an individual who was physically injured on the job while working in the correctional facility. It was found that he had problems with pain with his back. We did submit medical records to the commissioner that shows that he has an issue with a lumbar disc in his back. If this were a typical injury case or a workers' comp case, the settlement would be more than $6,000. I think that it is true that I think that the commissioner had a statute at the time of the claim that The maximum amount of award is 20,000. And he found that he issued an award of 8,000 and reduced it by 25% because of comparative negligence. I think at the very least, it shouldn't be hit. Mr. Ortiz's award should not be reduced because he maybe was not completely without fault when he got injured working. You know, that's not something that exists anywhere outside of a prison inmate working. Like, for example, the correctional employee who was working with him and got injured, if he submitted a compensation claim, there'd be no reduction because he was partially at fault for getting injured while on the job. So it's a little bit inequitable that Mr. Ortiz got a reduction for being partially at fault when he was working. So he wasn't properly trained, he wasn't properly instructed, he wasn't properly overseen. You know, he can't be blamed for his injuries on the job. And he's a man who's in his 30s. I think that a $6,000 award is just a little low. I think that the Judiciary Committee and the Connecticut General Assembly, in a gesture of good faith, fairness, and in the name of an adequate award, should award 15,000.
Yep. All right. Comment or question from members of the committee? Comment or question from members of the committee? If not, Attorney Tobis, it's good to see you again. Thank you for joining us.
Thank you.
Clive Milton. Clive Milton. Eric Westreed.
Good morning, Jim.
Good morning. You may proceed.
And thank you, Chairman, and the committee members. The Claims Commission dismissal is predicated on the assertion that I filed beyond the first year, the 1 year statute of limitations, while admitting that any continued violations of law by the defendants, DCF State Attorney and the Judicial Branch, that continue to this day would be placed in my file. If it is ongoing, that means that it's within the statute of limitations, especially if upon request, the Claims Commission's office, Erica Sells and Tara DuPont told me that I do not need to file a new complaint. This is a shock of conscience story of draconian, whole of government, effectually state-sponsored terrorism of a Black man, and especially the prosperity of his daughter by the stifling effects of systemic structural racism and stigma. This is an experience, sans the dearly departed, whose pain has ceased. That is the worst nightmare you will ever witness. Yet, I have been placed in an invisible prison when not in an actual one, and my child is denied any legacy of my success, stolen from her, preventing her father possessing 3 graduate degrees and 2 pending medical doctorates to provide an example and material support for her. Imagine your own child referring to you in the following way: "Mommy, mommy, there's that guy on your phone." That guy? A heartbreak no one should ever experience, much less the child who doesn't even know it yet. As I write this, I am being subjected, as I read this, I am being subjected to yet another daily violation of court orders, and I am powerless to use the government to enforce the rules. That is less than un-American, it's less than human. We have been failed by 2 branches of government. Let's not make it a third. And I just want to make caveat and thank, at least give credit to Judge Anna Facito, Judge Eric D. Coleman, Judge Barbara Aarons, and Judge Groggins, as well as Judge Shortall, one indicating that I was being set up in open court, and another that the state of Connecticut has destroyed my ability to earn and my reputation. There is a vast amount of information in the file. I'd like you to read my written testimony, as well as there is an over 600 filings on a docket. Who files? Most of them are mine. And there were over 600 filings. So there's plenty of evidence that give a broader contextual view of this. I have yet to give you the full context of this, but I hope that my written testimony will even just touch some of it. I wouldn't wish what has happened to me on anybody. Imagine not having your income for 2,901 days. Imagine.
Mr. Westry, your time has elapsed. Let me see if there are questions from members of the committee. Representative Fishbone.
Thank you, Mr. Chairman. Good morning, sir. I'm just trying to figure out what is your claim against the state?
Well, my claim has gone through myriad events of a government malfeasance, whether we're talking about the false imprisonment, the false warrants, using fraudulent information, the denial of medical care, being rushed to the emergency room because and when I talk about this, we may be talking about the police, but this arrest was directed by the state attorney's office, Maureen Platt's office, and Alexandra Arroyo for one of them. So it covers, it categorizes myriad violations of due process, of equal protection. My 14th Amendment have been violated, Fifth Amendment has been violated, Fourth Amendment has been violated. So I really, I don't think you have enough time to hear my story.
Okay, but this is the time. So I actually do. I booked out the entire day. So we if you want to talk about your case, I'm certainly interested. And I'm just trying to figure out, when did these incidents happen?
They're ongoing, sir. But
Okay.
if you want to start from the very beginning, the 5th of April 2016, but they're ongoing. To this very day, as I indicated, I'm experiencing violations that are happening to date.
Mr. Westry, I'm just going to remind you and anyone after you that many people have a story that is ongoing, that goes back very far. The most pertinent thing is the claim that is before this committee at this particular time. That is the thing that we need the information on. You may proceed, Representative.
Thank you, Mr. Chair.
Yes, sir. Yes, sir. But I'd like to add the caveat that the Claims Commission office indicated to me to continue to file additional violations in addition to what I've already described, the horrendous conditions that I faced, to continue to file that in the file.
I note that, and if you have those and those come before us, we will deal with those. I'm just letting you know the best chance you have of getting what you want out of this process, should that be what should happen, is to make sure that we understand what actually happened in this claim.
Yeah, so we're just dealing with the claim that's before us. Okay, with that framing, the claim that's before us, when did those incidents happen?
Well, those incidents started, the date of start would have been the 5th of April 2016. Some violations include 17A-101K-3 and 17A-101K-8 J. So that's just one incident, because there are 3 different entities that we're talking about.
Okay, so 2016 generally is when the incidents began, the claim that we're on today. And when did you put in your claim against the state?
Well, my claim went in, well, I'm not looking at the exact date, but it was in 2018. But even in 2018, DCF had violated Judge Shortall's order. So these matters, although there's an argument that, okay, that was 2016, there are events occurring when I filed that I included.
Okay, that's fair. I'm just trying to get a timeline down here, right?
Sure, sure.
So ultimately, the claims commissioner dismissed your claim, right?
Yes.
And when did that occur?
That dismissal occurred in 2023. I don't have the exact date. I wish that
Fair.
that you I can access that while we speak, but
No, it's
that-
not. 2023 is fine. That's just to pin down a timeline here.
sure,
And
sure.
to your knowledge, what was the basis of the dismissal?
The basis was something to do with jurisdiction as well as um, I believe a statute of limitations, which I find erroneous.
Okay, so let's talk about that portion. So the claims that you identified in 2016, it's your position here today that they are still ongoing?
Yes. Yes. In fact, as I relate to Judge Shortall, the hearing with Judge Shortall, who described the state having destroyed my reputation and ability to earn, it's permanent. So
Okay, so
that
the-
was 2018 when he made that that memorandum of decision. But yes, I guess the answer to your question is yes. These events have continued. We have issues with Judge Joseph B. Schwartz, who violated my rights just almost a year ago, while I was on my way to a pain specialist, which are related to the multiple conditions that I've suffered. Some of it from police brutality, some of it from violations of denial of medical care. That I'm now facing every day.
Okay, so let me just frame something for you because I'm just trying to get clarity. Let's just shift your situation to a motor vehicle accident, okay? In the motor vehicle accident, there's a bad act and you lose a leg as a result of the accident, right? That is the event that causes the damage as you go on. The impact to you is continual, right? But the accident that happened was the motor vehicle accident. So I'm trying to unpack between the bad act and the ongoing effect, right? So if bad act happened in 2016,
yes,
I can understand how you still have effects of that, right? That's ongoing.
yes.
But if the bad acts are ongoing, that's a different situation. So I'm trying to unpack, are the bad acts continuing to ongo by the particular individual?
Yes.
Or
Yes.
just effect?
Yes, indeed. So as I related, just to take the DCF situation, they have undergone under Maureen Dugan a vendetta against me. It has been a continuing vendetta. Judges have had to intervene to squash some of the bad acts that they have enacted. Okay, so yes, since 2016, it has reverberated, and the acts continue up until the most recent one when Judge Groggins, Judge Barber, and parents, and Judge Faceto, in effect shut down DCF for what they were doing to my family and I.
Okay, so when you filed your claim in 2018, though, you couldn't have claimed stuff that happened last year, right?
No, I couldn't, but I am talking about a continuing vendetta that occurred in 2016, that initiated in 2016. Now, let me just say this. When I'm speaking to the Claims Commission and they're advising me you continue to put these things in your file, they are by inference and actually openly saying to me explicitly, these are matters that are relevant to your case that you don't need to make a new filing. I was explicitly told you do not need to make a new filing for these events. If I had been told, no, you have to do these individually, obviously I would have done that.
Okay,
So
well,
when you're given the wrong information, or I think it was the right information, because it doesn't make sense for me to make when you look at that written testimony, you probably looking at dozens of violations. So why would I be doing that with Claims Commission when they're telling me to continue adding to your file? And I provided an email for the Claims Commission indicating how they were compiling that file. It is voluminous.
okay, I have to be truthful with you. I'm having difficulty trying to figure out what's before us here today. So if there's an ongoing course of conduct by the same individuals, then perhaps you filed your claim too early. Nonetheless, we're here on whether or not to overturn a determination by the claims commissioner as to the timeliness. So I'm just trying to pin this down because you decided to file a claim, right? And we are part of the reviewing process. So I'm going to try and give you another opportunity to try and, formulate what in particular you are claiming that the state of Connecticut did wrong that can be remedied for you. Can you answer that question like succinctly?
Well, yes, top of mind is that they, as Judge Shuttall indicated, and I hope that you will look at that statement, that the state has destroyed my ability to earn and has destroyed my reputation, my professional reputation. And that kind of information spreads like wildfire for what DCF did. Now, I'm only talking about DCF in this instance because you want me to be succinct. But if you want me to just deal with that one issue, imagine not having a career, not having an income for 2,901 days.
Okay, and I'm just trying to figure out, because you're sort of dealing with the loss of the leg, the effect, right? So what do you allege in particular? Was it you getting incarcerated? I'm just trying to figure that out.
Okay, now you're talking about the state attorney's office, but I'm talking about, I'm getting back to DCF. You're talking about the effect, but I'm telling you what Judge Shuttall told me, that in fact, the state, when DCF engaged in those actions, they violated my ability to earn income. So I'm not sure exactly if I'm being clear, but I think the judge's statement is extremely clear. And we go back to the origins. We're talking about
Mr. Westry,
2016.
I think the
April, sorry.
Westry,
Sorry.
I think the panel here is trying to understand, but there's something missing for us. So I'm going to make an attempt to see if I can get us there. So when you began your testimony, you began talking about if these things happened and you are already into the story. The problem, I think, is we didn't get the beginning of the story. And so when Representative Fishbein is setting up the paradigm where he's talking about the car accident, he's trying to get you to understand that most of what you testified to was the second part, the impact, what's going on. You jumped into your story there, and then we didn't hear about the accident itself. So you are suggesting to us that a state agency did something that had impact on your ability to earn, whatever the 2,901 days and all of that. I guess what we don't really understand is what is it that the state agency did that caused you to have that as part of what you are dealing with? I'm sitting here right now, I couldn't tell you. So if you can answer that question.
Sure. Okay, so the precipitating event was an arrest on the 5th of April 2016, which launched an investigation by DCF. DCF has probably, well, I don't want to say they've been the worst. I think it's the competing bad acts by the state attorney and DCF. But yes, if you want to go to the origin, and I said that in the beginning, that the 5th of April 2016, but to elaborate, the arrest that occurred, the false arrest that occurred, this case was dismissed, by the way, in 2017. However, there were supposed to be actions taken by DCF that were not taken. They violated my rights, and Judge Shortall, his findings indicated that they violated his order after that.
Okay, so slow down a minute for me. So first, you used 2 different years. I think you were talking about 2016 with the arrest, correct?
That is a precipitating event, yes.
I just want, because at one point you said 2015, but that's probably
Never to 2000.
Okay. Yep. That's fine. And so your claim has nothing to do with the arrest itself. It has to do with the action on the part of DCF.
No, the arrest was a false arrest, but the case was dismissed. So,
Sir, if you just answer that question though, right? Your claim has nothing to do with the arrest, right? It's about what DCF did.
no, actually, as I said, there are 3 different entities: the state attorney's office, DCF, and judicial. So no, all 3 of those are culpable for their actions.
Okay. Comment or question from other members of the committee? Comment or question from other members of the committee? If not, Mr. Westry, thank you very much for joining us.
Thank
Stephen Zoni. Good afternoon. You
Good
may
afternoon.
begin.
Thank you, members of the committee and leadership. I'm here on behalf of Mr. Charles Staples in support of House Joint Resolution number 174, confirming the decision of the Claims Commissioner to award Mr. Staples $1,550,000 relative to 11 years of wrongful incarceration, followed by 5 years of special probation, followed by 20 years on the sexual offender registry. Mr. Staples' case began in 1990 with the false allegations of his then stepdaughter, which resulted from undue pressure from the child's mother, which after Mr. Staples' arrest was followed promptly by her moving another man into the home, divorcing Mr. Staples, getting sole custody of her children, and divorcing Mr. Staples shortly thereafter. The case before the Claims Commissioner is supported by the affidavit of the putative victim, and Mr. Staples was exonerated in 2020 by way of an absolute pardon, unanimously granted based on the putative victim's recantation testimony. So I would ask that the members of the committee vote favorably on the resolution and confirm the award of the commissioner. Thank you.
Thank you. Comment or question from members of the committee, Representative Fishbone.
Thank you, Mr. Chairman. So just procedurally, if you know, how does this matter come before us?
The matter, Chapter 54, Section 102 UU permits claims for compensation for exonerated individuals within 2 years of the date of a pardon. And this case was finally timely filed within 2 years after the date of the pardon. And
Okay,
it's here after the decision of the Claims Commissioner after a hearing for the committee's approval.
So statutorily, we are required to have this before us, or I'm just trying to figure out, there's no challenge. If there's a sense, amen, go on. That's the position. right?
Sounds about right to me. The claims commissioner issued the order, and the state was represented in the hearing and in that claim by the Attorney General's office.
Okay, and they do not oppose, calculation is done, okay.
Not to my understanding. We reached an agreement as to the calculations at the time of the hearing due to some language in the statute that is indexes the computation of the award to the median household income of the Department of Housing and Urban Development, adjusted for inflation and so forth. And for the years that Mr. Staples was incarcerated from 1990 to 2001, the figures from the Department of from HUD, for Housing and Urban Development, are not available in full for those years. And so there was some dispute as to what the appropriate rate of compensation would be. And I understand there's a bill before the legislature to amend the statute with respect to the calculations and the figures from HUD.
Is there anything about your client's experience in being wrongfully incarcerated for 11 years you'd like to share with us that may help us in future deliberations?
Absolutely, Your Honor. Just the impact of wrongful incarceration on an individual, I think, cannot be understated. At the time of Mr. Staples' arrest, he was working he was an enlisted member of the Marine Corps, working with top secret clearances on, he was in digital cartography in the 1980s. And it's, as the Commissioner's Award notes that it's not hard to see how far he would have gone in that career through if he had been in digital cartography mapping through the 90s into the 2000s. I mean, he might be making significant money working for some powerhouse like Google or something.
And what was he convicted of?
It was sexual assault in the first degree and risk of injury to a minor. And he pleaded guilty at the time under the Alford Doctrine and has maintained his innocence all along.
And was is it fair to say, I don't know anything about the case, but based on what you said, that the conviction was solely based upon the statement of the alleged victim?
Well, it was a guilty plea. It is significantly based on the statement of the alleged victim, yes.
Was there DNA?
The police, the prosecution said they had DNA from a laundry basket, which was a shared family laundry basket. And it's my understanding that, he pled guilty to avoid facing a lengthy prison sentence, like 50 years. And he ended up receiving a sentence of 30 years with 15 to serve, and was released after 11 on good behavior.
All right, well, thank you. Thank you for coming here today.
Thank you, committee.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? If not, Attorney Zoni, thank you for joining us today.
Thank you.
Luis Ortiz. Luis Ortiz. Michelle Milton. Michelle Milton. J. Paul Vance. Good afternoon, Attorney Vance. When you are seated, you may proceed.
Good afternoon to the members of the committee. Thank you for the opportunity to address you today. I'd like to thank you for having this public hearing and for the process. It's really important, I think, for all the claimants to be heard, and you are all doing it with very empathetic ears, and that's appreciated. I am here on position number 68. It's Bill HJ 201, the claim of Guy Dinello versus the state of Connecticut. I respectfully submit that the decision that was created by the magistrate and signed off by the claims commissioner is incorrect. It's factually incorrect. The legal basis for the decision is incorrect. Without reading to you from the letter that I've provided to the committee in detail, the state of Connecticut, the Southern Connecticut State University, created a hazard and a dangerous condition when it improperly and negligently blocked off a pedestrian bicycle path on its campus. We have provided evidence that should have been support for permission to sue for Mr. Dinello. I can appreciate as someone who served the state of Connecticut as the claims commissioner, that the gatekeeper function of the claims commissioners is very important to make sure that claims that are unsupported are dismissed and claims that are foreseeable are allowed to proceed to permission to sue. This claim was denied for a couple different reasons. First, the claim was denied because the state denies that the closed gate was a hazard. Their denial was based on lay opinion. We have an expert engineer who has a specialty in human factors, and I've provided that for the committee as well, that indicates that this condition was in fact a hazard. It was not open and obvious because this was a gate that was closed in 2020 during COVID to keep people from using it, when for years and years, when Mr. Danello was a cyclist on this path, it was open each and every time he was on that premises. One of the other reasons the claim was denied was due to comparative negligence. I can remind the committee of the case Blonsky versus the MDC, which is a pretty well-known Connecticut case where the plaintiff was injured on a cycling accident on public land. That decision included some comparative negligence where it shrunk down the award. What we're seeking on behalf of Mr. Danello is to have this case be decided in Superior Court, having the permission to sue be granted, or in the alternative, have this claim be remanded to the Claims Commissioner for a full hearing so that counsel would be able to cross-examine some of the lay witnesses as to their credibility and expertise, and be able to put on our own witnesses. Thank you. I'm happy to answer any questions, and thank you again for your time.
Thank you. Comment or question from members of the committee? Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon now, sir.
Good afternoon.
Can you just set the stage a little bit more on this? Because I keep on hearing bike path, pedestrian path. My understanding is that the gentleman who got injured was not a pedestrian. He was a bicyclist, right?
It's a bicycle path on the campus of Southern Connecticut. Mr. Danello actually, not only was we could call him probably an expert cyclist. He owned a bicycle shop in New Haven. He would use this path each day to go from his home to his bicycle shop. This was a path that abuts the football field at Southern Connecticut. If you've ever been on the premises, green with a green football field, a green gate that has openings in it, so difficult to discern with the eye. And that's one of the things that the expert witness would testify to. And I provided sort of an outline of his report for the committee so they can see that this was not a solid green gate that was closed and was closed every day. This was a green gate that had openings and difficult for a cyclist to discern. I know that it would never be admissible in court, but in fact, after our client was injured, what Southern did was put yellow tape, stop signs, et cetera, over it. Now, I know that would not go into evidence at court, but it's important, I think, for the committee to hear that, in fact, Southern realized, oh, wow, this is dangerous. Just because it hadn't happened before, the gate had not been traditionally closed. So what we wanted to do was have either the claims commissioner in a full hearing or a judge in a full hearing be able to weigh that and decide whether or not our client's comparative negligence was in fact more than 50%. If it was, he loses and walks away with nothing. But this case was dismissed as if it was a frivolous claim. And in fact, if we were going to follow other case law in Connecticut, it's not a frivolous claim. It's one that should be heard.
So one of my concerns that I heard about through your testimony was it appears to be a due process situation.
Sure.
My understanding is that the AG's office was permitted to file a motion to dismiss and to attach affidavits. Did you have a similar opportunity?
What we provided instead of affidavits from fact witnesses was, besides the allegation, we provided expert testimony, an expert disclosure that was attached. So could I have had other witnesses? The sole witness that I would have had besides the expert would be Mr. Danello, the claimant, who pedaled and crashed, suffering a couple broken vertebrae. I didn't have the names of the individuals in the affidavits. I had a police officer that responded after the fact, but I'm not sure if even as a police officer, and as you know, I have plenty of respect for the police officers, having been raised by one, but I don't know that their expert testimony as to the engineering problems and design of the gate would be sufficient to countermand our expert.
All right, so I'm just trying to get once, you know, because I wasn't part of this, right?
Sure.
You lived it, I didn't, or are living it. They submitted, they being the AG's office, submitted affidavits from workers at Southern, is that fair?
Correct.
Okay, and you are not knowledgeable as to their acumen in engineering or anything like that?
Correct.
Okay. And and they're saying not a hazard. And in response to that, you had someone say, yes, it was a hazard, right?
Essentially, Mr. Representative, I had that expert prior to them having some fact witnesses that said, oh, well, we can see it from 100 feet away, so clearly it's not a hazard.
Okay, once again, I'm just trying to figure
sure.
out what the claims commissioner is looking at, right?
Yep.
So they have lay people, not a hazard. And what did you submit to support your position? It was a hazard.
Yep, the expert disclosure from the engineer that laid out that there were insufficient warnings, that the visual acuity of any cyclist would not be able to perceive these gates.
Okay,
So more steeped in science as opposed to folks that say, you know what, it didn't look like a hazard to me.
yeah, okay. So just looking at that, it appears that the acumen of your testator was a little bit of higher grade substance scientific than theirs.
I would hope, and that would be up to
I
the judge or the claims commissioner to decide, right? And to give weight to the credibility.
Sure, but at the end of the day, the claims commission determined that it was not a hazard and therefore said you cannot bring the action. Is that fair?
That's one of the reasons for the dismissal.
Okay, so let's put that one to the side.
Yes.
And what is the next reason for the dismissal?
Lack of notice,
Okay,
saying that in fact that they deny that the closed gate was a hazard, but they say that if it was a hazard, the state didn't have notice that closing that gate on that day would be notice sufficient to have been forced to act.
so a typical premises liability
Correct.
defense. Okay.
Absolutely.
All right, we're gonna push that one to the side. What's the next one?
The last one was comparative negligence, saying that Mr. Danello was in fact the one that was negligent. And it's a fair claim, but in fact, I point to that case again, the Blonsky versus MDC. It's a cycling accident on public land. It's very fact similar, and this is what Mr. Danello seeks is that same opportunity to put on a hearing or a trial so that the person that's weighing the facts can hear the evidence and hear testimony.
And how did you submit the case? Did you ask for permission to sue or did you ask for an amount certain?
I asked for permission to sue, and I asked for an amount certain in excess of the claims commissioner's jurisdictional limit. So permission to sue.
Yeah, okay. What are the damages?
He suffered 2 broken vertebrae. He has recovered, but he was out of work for 6 months plus. Had some pretty substantial medical bills and lost wages.
Okay, were the medical bills paid?
Medical bills were paid for by Medicare, so there would be a lien.
There's no, well, there'd be a lien, yeah, but those are negotiable. And then there's no permanency.
No, there's permanency. He's healed,
Okay.
but his physician would attribute this as a permanent nature to his injuries.
Did you get a rating?
I did not get a rating. Not a number rating because this was not a workers' compensation claim. So the medical records say that he suffered a permanent injury. Didn't ascribe a number to it.
So is it a coupon? I mean, that's what we used to call them. So they can't put a number on, they can't put, you know, because usually it's,
I never heard that.
yeah, it's, we used to call them coupons, you know, where it's so low that the evaluator could not put a number on it. So usually it's
I don't think it's that.
permanent.
I've never heard that though.
It's set.
We shop at different stores, I guess.
As a clerk, we
Yeah.
called them coupons.
Oh, that's funny.
You
No,
know,
two broken vertebrae in his neck. You know, didn't sever his spine, had a concussion. So I don't want to cast anyone aside and
well, I look forward to hearing what others have to say about your case.
Thank you.
Thank you, Mr. Chairman.
thanks very much.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? Senator Kissel.
Yeah, I just want to say, Counselor, thank you for your service in the past as our claims commissioner. I thought you did a good job when you were in that role. And is your dad still with us?
Geez, Senator, he's only 72.
All right.
He started very early with me, so he is, and sometimes he's in this building. But
All right.
thank you for your compliment. It was a tough job, and I'm really happy with my predecessors. You know, we have the commissioner here. I think he's doing an excellent job, and I really think the role is a tough one, but as long as someone listens with empathy, I think it's important.
Well, probably the greatest testament in favor of our new claims commissioner is that even folks that are challenging his decisions today and the decisions of his staff are all saying nice things about him. So that's always a good sign. But tell your dad I said hi, and
Well,
I thought
thank
he
you.
did an excellent job as the spokesperson for the state police over all those years. Thank you for coming to testify.
Thank you, Senator. Yeah, 42 years. I think he's earned his pension at this point. He did a great job. Thank you for saying that.
All right. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, thank you very much for joining us.
Thank you very much.
Peter Prestley.
Hello.
Good afternoon. You may
Good
proceed.
afternoon. My name is Peter Presley. I represent Cynthia Dabbs Lindenberger in matter 26168. This is a complicated case factually and not so much illegally. And I've set out a lot of the detail in the statement that I submitted in connection with this testimony this morning. I think it's probably productive to begin by stating what the case is not about. This is not about whether the claimant is entitled to retroactive benefits as well as prospective relief for some pension claims that she had made under the Connecticut State Employees Retirement System. She believes that she is entitled to retroactive relief back to the time when she could have retired beginning on the middle of 2015, but was denied the ability to do that. What it is about the state's denial of her Tier 1 pension status for over 30 years. And it's and then after that 30 years, it's admission and allowing her to transfer into Tier 1, but only prospectively, not retroactively, and basing that on that she should have, basing that on the notion that in order to be able to get retroactive relief under the pension system, she would have had to make the decision to retire as of that date in mid 2015 in June, and then disputed her pension status as to whether she should be on Tier 1 or Tier 2, and after she was in retirement status. That would have been a very difficult thing for her to do because when she, for the last 30 years, the state of Connecticut had been telling her that she was a tier 2 employee and she had never elected a tier 1 transfer. So it would have made no sense for her to do that since she had no access to any of the documents, notwithstanding her requests for any basis for the state's denials of her tier 1 status. That's the first thing. And then secondly, if you retire
Attorney
at that date, pardon me?
Your 3 minutes have elapsed.
Okay.
We're going to see if there are questions for you on the committee. Are there questions from members? Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon, Attorney Presley. First of all, can you just orient myself or me? Which matter is yours? What number on the agenda?
It's number 16, I believe. And it's 26168.
Okay, Christopher Haspel?
Yes.
No.
No. Okay.
Cynthia Dabbs Lindenberger.
Okay, so 75, I'm being told, is your number.
Okay.
Okay, that's Cynthia Dabbs Lindenberger. Okay, so I got that. So now Cynthia was an employee of the state of Connecticut for, if you know, what dates?
I think 1982, 1983.
1 year?
No, that's when she became, I thought you said that's when she started her employment.
Okay, that's when she started. Okay, and when did she leave?
She left employment in 2018.
Okay, and was she a collectively bargained employee?
No.
Okay, what did she do?
She worked at the American School for the Deaf and was under the state system due to that status.
So when you say under the state system, she was under the state pension system.
Yes.
As a teacher.
Yes.
Okay, so, and I, certainly very much appreciate education for individuals that are hard of hearing. Is the American School for the Deaf a extension of the state, or is it a private institution that teachers can claim the pension from?
I think it's the latter.
Okay, so she was like a municipal teacher that utilizes the state pension system.
Right. She's in that class of employees that is part of the Connecticut State Employees Retirement System.
Okay, and that system is governed by a contract, right? The not the underlying collective bargaining contract, but the pension agreement.
You're getting into some background that I'm not familiar with, but I'm not sure. I don't know the answer to that question.
Well, and that's because you talked about that something should have happened. Benefits should have been transferred. She should have had opportunity to do certain things regarding the pension. Is that the claim that's before us?
Yeah, I guess the problem with this case is with the 3 minutes that I was allotted, it's a very complicated case. But the bottom line is that when she started in 1982 or 1983, soon thereafter, the retirement division, I believe, sent her a form to elect whether she wanted to transfer into tier 1 from tier 2. And she duly and timely executed that and sent it in and expected to have been transferred, as were other people that did the same thing, to tier 1, so that she could work out her career and enjoy the benefits of that tier. Right from the get-go, she never was transferred after the door closed to make the election. So she repeatedly, over a 30-year period, went back and back and back and to see, why am I only a tier 2? I wanted to be a tier 1. I qualified for it. Anyway, so she kept going back and forth, and she was never given any excuse or satisfaction. So in 2018, in February, I'm getting to what I hope are the key issues here. In 2018, her husband had some operations, they had some problems, family problems, and she had to consider retiring even under early, given the age and service requirements of Tier 2, early under Tier 2, and found out that she couldn't possibly afford to do that. But in the process of discussions about whether she could afford to retire under Tier 2, the proverbial honest man surfaced, and she interacted with him, and he said, I don't know why this has been a problem. You've had a signed and acknowledged transfer form for all these years. And she said, well, you're the first person that ever told me that. And she said, well, will you please send me a copy of the election form, which she duly did. And
No, I appreciate that. And I'm just trying to figure out, because you said a little while ago that for years, you know, every year she was contacting them and saying, how come you haven't transferred me yet? But
right.
now I just heard that in 2018, which is many, many, many years later, she was told that. So can you just put that together?
I was just trying to explain the circumstances when it arose. When she was, normally when she would call in for to inquire about why she was in Tier 2 instead of Tier 1, she would deal with a lower level person who would say, I'll get back to you, and then they wouldn't get back to you. Or if they did get back to you, they said, I have no basis upon which to believe that you are or should be included in Tier 1. So when she was going through the sort of can I afford to retire analysis, she by chance spoke to a more senior person who pulled her file and said, yeah, of course you can be in Tier 1. What are you talking about? You made the election. We acknowledged it at the time that we made the election. And then this is the next point is that she was given a chance to buy back into Tier 1, which she did do. However, she's made a claim, and this is really the gravamen of what's going on here. She made a claim that she should be made whole for the fact that she missed out on the chance to have an early retirement, because when she was 55 with 25 years of service and qualified for a Tier 1 retirement, she was prevented from doing it because she was stuck in Tier 2 and nobody would listen to her. So she was put into Tier 1, but she never was able to convince them to allow her to get benefits that would have accrued to her had she been able to retire, had she been classified properly from the beginning.
How much did it cost her to buy into Tier 1?
$70,000 or something like that. So
so what did the claims commissioner do? They dismissed based upon what?
Basically what they said was that this was a benefits case, and no matter how derelict the commission was in its duties, that they couldn't be punished by bringing a breach fiduciary duty case against them, because there's a remedy under law for the underlying benefit. So as I put in my papers, it's not malpractice if the person just doesn't die. I mean, the fact that what they did in delaying her in servicing her proper entitlements is not. It's a whole different subject matter. It's not like, and I think that the gravamen of what they're saying is you can't avoid going through the process of seeking these benefits through the normal administrative channels by collaterally saying they screwed up. Well, what she did do, she did go through those channels, and she got to the point where she was supposed to bring she brought a declaratory judgment action before the state commission and was denied, and her next avenue of appeal would have been to go to court. And frankly, she didn't have the money to go to court.
When
But
was, when was that case unsuccessful?
in 2023.
And when was the claim here filed?
This claim was filed in 2000. Oh, let me see. I think it's November 2020.
Okay, so while the claim is pending with the claims commissioner office, a collateral action is brought, which is unsuccessful. And the basis of the claim is breach of contract?
Before the claims commissioner?
Yes.
No, it's a breach of fiduciary duty. And the duty, and I think it's I briefed it. I think it's extraordinary that she basically was stonewalled for 30 years, and then finally was given relief when somebody finally admitted that they'd known this all along. They just didn't admit it to her that she was entitled to the transfer.
But
and then on top of that, then the relief they gave her, which was much appreciated, was allowing her to buy in, was only prospective. It wasn't a complete rectification of her situation.
But absent a contractual clause that the state assumes fiduciary responsibility for the employee, how do you get there?
Okay, well, first of all, to me, there's two statutes that I think that are important to her. And the first statute is the statute, and I won't go into it because it's all brief, but statute that basically says that the Connecticut State Employees Retirement Commission and the division to which it delegates the authority is charged with the fair administration of the benefit system, and that's its essence. There's another statute that's cited in the materials that says basically in the execution of these duties, it can't violate the duties of trust and fiduciary standards that it's supposed to operate under. Completely different statute, and basically sounds in tort. It's a statutory codification of the old breach of fiduciary duty common law causes of action. So it's a separate cause of action, and one of the reasons that I think it's important in this particular case, and why I wanted the legislature to think about this, is that the reason that they have given to her in this case, in their briefing, and in the what I call the benefits case, this is the fiduciary duty case as far as I'm concerned, is that it's clear that it's not legal to provide retroactive relief, which means, in essence, practically speaking, for this situation, she would have had to retire in June of 2015 in order to be able to argue the case that she would be entitled to benefits from that date. And so I read that's the statute that says that. It's
Can we just stay focused on where the question? So you cited two statutes.
Right.
The first one really has to do with the administration of the fund, right? That's what that has to do with. So the second,
well, also, the fair administration of the pension system, not just the funds, but
sure. Okay, but it's basically the same thing. The second one, are you saying that the second statute, which you haven't given me a cite, creates a fiduciary duty by the state for a pensioner?
Yes.
Okay, what's that statute?
It is. 55-155A, small c, 2.
I'm writing this stuff down. Okay, and then I may have asked you this, and I'm sorry to go long on this one, but the basis for the dismissal was that it was benefits related and not something like a quasi contract, right?
No, it basically said it's a benefits case and needs to be prosecuted through the normal administrative process.
Which is what?
You can't avoid doing that by misnaming it as a breach of fiduciary duty violation. That's basically what they said.
What normal administrative process are you recognizing would be the alternative way?
Well, I think, frankly, in order to, well, first of all, this is not about benefits. I'm not sure I understand your question. At this point, what she was seeking initially, and we tried to get the commission to agree to do, was to get the actuaries involved and see what would be the best way to figure out how you could make her whole for having not the consequences, the life consequences of not being able to retire when she should have been able to do that. But what it cost her in dollars and cents not to be able to do that, and how can that be rectified? Would she have to buy in further? Those kind of, and that it was that we were just completely shut out and said we're not even going to discuss that because of this rule. There were several things they said, but the real gravamen of what they said was this other rule I was trying to refer to, and that is in order to be able to get retroactive pension to that June 2015 date, you'd have to have retired, and they cite a statute to that effect, and that's I think it's 5162, and the reality is if you look at that statute, it doesn't say that at all, and to the contrary, I think it's clear that when you look at how this particular claimant was treated, from the 30 years of her denial to the perspective to claiming this rule, which is relied upon to deny people full relief when the state's in error. I think the cumulative effect is that she's been that the system is going off the road, and she's been and again, this gets to it's very important for her to be able to
Attorney Presley?
Yes.
I'm going to ask you, as I've asked others, to try to answer the question, but not go too far afield.
I'm sorry.
The question itself is, so that we can get the appropriate follow-ups and make sure that others who are waiting to testify get their opportunity.
Yeah, my problem is that this is a very complicated matter, and it doesn't lend itself to.
I recognize that Representative Fishbein is really good at asking the questions.
Yeah, right. Thank you. Well, I just want to get. I was really actually trying to get to the basic point is I think that the
Attorney Presley.
Yes,
I'm gonna have Representative Fishbein ask his next question.
Oh, of course.
Yeah, I think you're making this a lot more complicated than it ever needs to be. So
sorry about that.
Please, I mean, I ask questions for a reason. So if we can just stay focused on that, it would be really helpful. So the denial, the dismissal, you said that the claims commissioner said this is a benefits related case and should follow the regular administrative procedures. So my understanding here is we have an individual who is not hired by the state. Their only connection to the state is this pension agreement, right?
Right.
And you said that you haven't seen the pension agreement, So you're unaware of whatever clauses are in there that would require one to follow if they have a problem with the pension agreement, right?
No, I don't think that's an issue. I think she has followed the dictates of what you need to do to try and get your claim considered in terms of whether or not you're getting the right pension or not. I mean, she's done that. And as I tried to distinguish right at the beginning, we're not seeking any alteration of her benefits that are going to be paid under the pension system. She's given up that because she thinks she's entitled to relief, but she's not going to pursue that because frankly, she doesn't have the funds to go to court and hire actuaries and fight the state. She doesn't have the means to do it. She's got long COVID. So we're not pursuing that claim. But what we are pursuing is saying the state in these actions collectively have breached the duty of the fiduciary duties that are imposed on the statute that I referred to. And that's what we want.
I understand what the case is about, and it's not a class action. So we're just talking about this particular case. So when you say collectively, I've got to stay focused on this particular case. But what is, and I still haven't gotten an answer to this question, because collectively bargained employees, if we have a dispute that benefit related, usually that's in that contract and there's an administrative procedure to follow that, but we're dealing with the pension. So what is your understanding as to the claims commissioner saying, because it's benefits related, that you should go through the ordinary process? Are they saying you follow the process in the collective bargain agreement? What are they saying?
No, they're saying basically as any other state employee or any other employee who's entitled to be in tier 1 or tier 2, the same procedure has to be followed. And so she's done that. She followed that. She went through a couple of levels and she filed a declaratory judgment action that was denied. And her next step would have been to take it to court. And as anybody else who was a state employee who was entitled to benefits under the state retirement system could do.
Okay,
what I'm suggesting is, and if you're a benefits lawyer, as I have been for a long time, in addition to that, there are these fiduciary duties that they're basically tort claims, and they're not mutually exclusive.
Okay, and I'm just trying to figure out, I mean, are you saying that the claims commissioner is identifying an administrative procedure that doesn't exist in this state?
No, she basically said, I think the reasoning, if I may put words, is basically you can't circumvent the administrative system. In other words, you'd have to go to court in order to try and get retroactive. We're not going to allow you to end run and claim that there's a breach of fiduciary duties. And I'm saying that I think there is a clear breach of fiduciary duties. And I think that not only in this individual case is it important to establish that, but for other people who are going to be prejudiced by this, you have to bring you have to file for retirement before you can claim any wrongdoing with respect to your pension. I think that's not supported by the statute that they're referring to, and I think it's basically a drift of the commission towards wrongfully denying people benefits, and it's high-handed, and I don't think it's valid. And I think on a policy issue, so individually, what I thought naively or not is that I thought that it would be of some interest to the legislature that these types of restraints are being imposed on people. And one of the ways to deliver a message is to look at the conduct and to allow her to proceed and prove her damages with respect to the emotional distress and possibly punitive damages.
Okay. We're gonna look at the case before us, the facts of the case, and in terms of policy, we deal with that through pieces of legislation.
Okay.
Are there questions or comments from members of the committee? Questions or comments from other members of the committee? Seeing none, thank you very much for joining us today, Attorney Preston.
Thank you very much, everybody.
Next is Rosa Kleneski.
Good afternoon.
Good afternoon. You may proceed.
My name is Colette Nicole, and I'm appearing for Rosa.
We don't allow that to happen. We have a process where those who are signed up may testify, particularly when there was an advance notice. Ms. Kleneski can send information to the committee on her case. I'd be happy if she wanted to contact us, but we don't allow that, and I'm not going to make an exception because we have throughout this year and previous years denied others, and it would not be fair to them. So if you or Ms. Kleneski want to send something to us or contact us, I would be happy to talk on the phone, meet with you, but we're not going to allow that. It would not be fair to all the others we denied.
My name was on the form.
Your name is not on the list.
I put my name in on the Zoom call that I would be appearing.
You did not sign up for testifying at the public hearing. You signed in under Rosa Kleneski. That's a different thing. Okay, so you can still provide us with the information, just not in this forum today.
Okay, can you give me the information that I would be using?
If you or Ms. Kleneski contact our committee administrator, that information is online. We will make sure that you have the opportunity to do that.
Can you give me the name of your administrator?
If you hold on, and I'll get the administrator to make contact with you. I don't want to go back. There are people still to testify.
I
So
know. I've been waiting since 10 a.m.
I understand. Again, this happens, and we have denied folks. I don't want to change
don't. I'm not asking to testify, just a contact that I could.
We will get. Hold on. Her name is Kirsten.
Okay, no,
You can if you go to the CGA website and you look for the Judiciary Committee, there is a phone number, there is ways to contact us, and someone will respond to you and make sure that you have your opportunity.
I appreciate that.
Absolutely. We have Elijah L. Hodge Bay to be followed by the Claims Commission.
In the name of Allah, there is no God but Allah. Thank you for having me today. My name is Elijah Al Hajbay, and my name stands for the one closest to God, destined to govern. So today I have lived my destiny. Since I've been 7 years old, I have studied the Bible and read all the encyclopedias. Here's a encyclopedia from North Carolina that represents my family. We have been on this continent since 1365. My fathers have been 17 chiefs, and I'm currently the chief of the Tuscarora Nation. I wear the massacre of Tuscarora on my sleeve. I'm here today because I filed a lawsuit against the Bank of Windsor. They have stolen $1.5 million from me under a pre-remedy judgment in the state of Connecticut. I have been blocked for 15 years from even having a trial. I spent over $200,000 on 4 lawyers, never gotten a chance to speak before anybody. So after they found out who I was, the judge said he did not want to be a part of this. He was the first person that was honest and filed a claim against the claim commission just to receive my money back that was under a pre-judgment remedy, which the Constitution state that it is unconstitutional to hold someone money until there is a judgment. There have never been a trial. I have never attended a hearing. So money was taken illegally. I was denied due process and equal protection under the law. and denied privileges and immunities. I paid the attorneys everything that they asked for, but they were sneaking into court. And I get an email 5 o'clock in the morning stating that this is attorney such and such, and I'm representing your attorney against you. And I'm like, what? I just spoke to him. And I'm in New York. My attorney knew where I was at. I zoomed to Connecticut. I get to Windsor at 8:30, get my vehicle, come back home. Come to the court. I go into the courtroom. I see my attorney. I said, and he took off running. So I stopped the attorney that he was with, say, hey, what is going on here? The judge ruled against you. Ruled against me on what? Oh, he ruled against you. So I said, well, what courtroom did you come out of? Over there. Said, you're more professional than that. Can you tell me what courtroom did you come out of? So they stole all my money. They've been blocking me because I caught the judge. And it wasn't me that filed the complaint. It was the appellate court that asked him, you have to justify what you've done.
Your time is elapsed.
And he lied.
Let's see if there are questions, comments. Representative
Can you speak in the mic, please?
We're going to get you a question. Hold on a second. Representative Fishbach.
Thank you, Mr. Chairman. Good afternoon, sir. I'm just trying to orient myself. Do you know where you are on the agenda?
Excuse me?
Do you know where your case is on the agenda?
The case was withdrawn back in 2009.
No, I'm talking about the agenda that we have here today. I've got like 7 pages. Number 28. Okay.
Say it again. I can't hear you, sir.
Okay, so you are Elijah
L. Hajbe.
Okay. And I heard about the Bank of Windsor.
Yes.
And so you have a case that's pending in Superior Court now?
No, I have another case pending in Superior Court now. That's a totally separate matter.
Okay.
And that's because the city of Hartford and the state tried to flood out the city of Hartford, and I stopped them from doing it.
Okay, so I'm talking about, you were talking about a prejudgment remedy that somebody issued against you, right?
Yes.
Okay, and when did that happen?
That happened in 2009. What I came up with is a strategy to have them sue me. That way I will be able to get discovery. So when I sent him a letter stating that if you're not going to complete this deal, return my money. He ran and got a lawyer. Next thing you know, there's like, well, we're not going to do this deal. We want you to pay out all the money. They stole $289,000 and thought I was going to pay that money to them, but I didn't. So I filed a counterclaim against them, and that's when everybody started panicking. So now they came and said, hey, we want to settle this. All right. Lisa Silvestri was my attorney at the time. At the same time, she was going through a federal prosecution because her brother, which was Paul Sylvester, which is the totally different name, they were all in cahoots ripping off the state. So she had to resign and she didn't go into court. And so the bank snuck in and started filing motions against me. They filed 500 motions in 11 years, 3 summary judgments, 2 pre-remedy judgments, no trial, no case. And every lawyer, I paid them. Okay. And they sneaking out. John Williams supposed to be one of the best civil rights attorneys in Connecticut. And then at the last minute, he going to tell me I'm on a big murder case so I could send my assistant with you. And I'm like, your assistant don't know anything about my case. He's like, yeah, I filled them in. So I called his assistant. He said, I don't know nothing about your case. I said, all you have to do is show up and I'll handle it. And when I announced that I am the chief of the Tuscarora Nation, that judge said, I am not getting involved with this because y'all screwed up.
Okay,
y'all should have known who he was.
I'm trying to get involved with this, okay? So I think my question was when? So the answer was 2009, right? This is when
it went from 2009 to 2019.
Okay.
And that's when I filed claims against the state to just get my money back from the pre-remitted judgment. But they said at the time, we cannot
Once again, the
settle this.
question was, once
Huh?
again, the question was just when, okay? So we
2000
know,
June of
got it,
2019.
okay? We're gonna, I mean, I got all afternoon, right? But
Yep.
if we can just stay focused, it would
All
really
right,
help.
I'm gonna jump in again, because I've said this.
Sir, all I need you to speak is into the
Hold-
mic.
hold-
That's all.
hold
I
on.
can't hardly hear you.
Okay, I'm gonna jump in again. On these questions, we're trying to get the information as it relates to the case. So there's a lot there. There's a whole story. We understand that. We're looking for specific information about your case.
No.
Yes, we are.
Oh, you were right. I'm sorry.
Yes, we are looking for specific information about your case. So, if you've been here, I've watched you all. You've watched all day. You've seen me say to people, answer that particular question, and then there's a follow-up that pulls out more information. Don't try to go ahead and give up the information, because what that actually does is it extends how long it takes to get through this.
Yes.
Right? So let Rep. Fishbein ask the questions. Others may ask questions. Let them ask the follow-up so we get clarity. And if there's something at the end of that that didn't get asked, or you think, I'll let you have that opportunity. Okay. So just let them ask the question, respond to that question in terms of the date and not all the other stuff. And we'll get around to your whole story. Okay.
Yes.
And Rep. Fishbein, I tell you the same thing. Don't jump over top of the witness testifying. Representative Fishbein, you can ask your next question.
Thank you. So, sir, I went on the judicial website and I see a case, it's Fidelity National. Is that the case you're talking about?
No, you won't even see it on that chart because they removed it was Reliable Mechanical. I mean, Windsor Federal versus Reliable Mechanical, Windsor Federal versus RMC Property, and Windsor Federal versus Elijah Al-Hajbeh. They removed it. So that's some of the stuff. They removed it off the calendars.
Okay. So, because in my understanding of procedure, you had said that there's a prejudgment remedy out there that was issued in about 2009. Is that correct?
The prejudgment remedy was issued in 2010.
Okay, so it was 14 years ago.
Yes.
And you're saying that that prejudgment remedy still exists?
Yeah, and nobody want to tell where's the money. You took $1.5 million for a $25,000 debt that I didn't even owe. So you taking $1.5 million for $25,000?
Okay, so the way our procedure works is a prejudgment remedy. You have to bring a lawsuit within a year. Otherwise, the prejudgment remedy goes away. So did they bring a lawsuit in 2011 or between that period of time?
They bought the lawsuit in 2009. They got a pre-remedy judgment. When we went to court in 2009, they called it off, and they got a pre-remedy judgment without any notification, knowledge, whatever, in 2010, in December 2010. Then they filed for amendment in 2011, January of 2011, and took 189,000 cash and start foreclosing on my properties.
Okay, well, they can't foreclose on a prejudgment.
This is what I know what they can do, but look at the record. And that's what I'm saying. They removed all the record. You have over 500 motions. They start foreclosing on all of my property because the bank had all of my information. So now all of my creditors start filing judgments against me. Now I had 1.5 million in assets, only $200,000 in debt. So my attorney Ricketts said, listen, I know this judge. In order for you to get justice, you're going to have to file for bankruptcy so this case could turn federal. Okay, so I did that, but I told him I can't file for bankruptcy because I do work for the government. And one of the stipulations is you can't file for bankruptcy. So he said, no, this is just a strategy to get it in federal court, which was a lie also.
Okay, so I'm just trying to get to your claim against the state alleges what?
The claim against the state is they allow the prejudgment remedy without any due process or notification whatsoever.
So that prejudgment remedy that went into place in 2010, right?
Yes.
Okay. And when did you first learn of the prejudgment remedy going into place?
Say it again.
When did you first learn that there was a prejudgment remedy against you?
Once my assets was taken in 2011, because I got a call from New Haven Housing Authority saying we have a judge, we have to turn over your money. I said, looked at the paperwork. I said, first of all, this is not signed by a judge. And I said, and I don't owe this debt. That's RMC Properties. It have nothing to do with this contract. So they said, well, hey, our hands are tied. If you don't sign this waiver against us saying you're not going to sue us, we're going to get rid of your contract. So I told him, you get rid of my contract because I'm not signing that.
Okay, so in 2011, you knew about the prejudgment remedy. You were contesting it, at least verbally, right? You were saying this is wrong, right? When did you file your claim against the state?
The case was pending from 2011 to 2019.
Okay.
So I filed it just 2 weeks, about a month before the case was withdrawn against me. So they said, we cannot, first of all, this is premature. So you can't file a claim while your case is pending. That's the next day I had got the decision from the court saying it's been withdrawn. So now they filed a motion to dismiss the claims commission. I filed a appeal and they came and said, well, we can settle this, just give us time. So they waited 4 years. I called the commission every 6 months. Where's my case? Where's my case? They allowed the commissioner to retire 2 weeks before her term was expired. Now they just hired this new gentleman and he came in with 2 months and said, well, you can't sue the state anyway because a judge can do anything that he want to do. But he forgot the judge can only act within his jurisdiction. I was not in his jurisdiction and the appellate court told him that, but he lied and they falsified documentation with my signature on it. And that's how I was able to survive because I told them, that's my signature.
Okay, so after all that, the question that I asked you was, when did you file your claim? And
in
I
June
haven't
of
done that.
May of 2019.
Okay, so in 2011, you knew that at least you felt there was an issue with this prejudgment remedy and that you didn't have notice, right?
Say it again.
In 2011,
Yep.
you said that you knew about the prejudgment remedy and you were saying then this isn't fair.
After my money was taken, I
Sure.
never got a chance to eat. And if you look at a prejudgment remedy,
I got it.
they
Yeah.
have a right. I know your attorney, so they post to notify you, and you can appeal the decision to say, "Hey, I can post a bond for the amount." I was never given the opportunity to post a bond because it was for you saying I owe you 25,000. You took 1.5 million.
So you know something about the statute. The statute allows you
Yes, I do.
at any time to file a motion with the court to reduce the amount of the prejudgment remedy, as well as to substitute the prejudgment remedy with the bond, right? So in 2011, you knew about, that this bad thing had happened, right? At least from your perspective. I'm just trying to figure out, we're sitting here today on a claim, right? And I think from what I can glean from what I've seen, that the claims commissioner may have taken the position that you waited too long to file your claim.
No, that's not true because like I say, I hired 4 attorneys. I paid each one of them.
Yep.
I paid John Williams $40,000. I paid the attorney Ricketts $10,000, gave him $35,000 to hold and said, listen, hold this money for when we go to trial because I don't want you saying I owe you money because he told me to take the money out the bank. I took it out the bank, but I didn't want them to say I committed fraud. So I gave it to him to hold. So I also paid Lisa Silvestri. So I paid, and then like I say, you cannot file a claim while the trial is still pending. And it went from 2009 up to 2019.
But maybe it's a disconnect. I'm just trying to figure out, you said that your claim is because they improperly put the prejudgment remedy on you and what you own, right?
The trial was over. The trial was over and the money was not returned.
Got it. But you
so in 2019, the trial is over. There was no trial whatsoever. So you're supposed to get back. They're supposed to make you whole plus damages for holding your money that long or post a bond. They didn't even allow the bank to post a bond. So the state is responsible for that money because they allowed them to do everything illegally. And when I caught them with the judge, you know, that's when everybody started panicking. I filed complaints with the judiciary. I went and filed grievances. The grievances was denied against the bank attorney, my attorney, but he said, yes, criminal activity did happen and he recommended prosecution, which they denied.
Okay, so to your knowledge, why did your claim get dismissed?
They said the claim is being dismissed because the amount is too large and he does not have the authority to rule against a judge. So that's why it was dismissed. It said he don't have the capacity or the authority for the amount because it was too large and it was against a judge. But he said, however, judges have judiciary immunity. And I'm telling him, if you use that argument of sovereignty immunity, then you have to understand that I am Tuscarora and you are in violation of the treaties of Ghent and the Treaty of Paris. We did not ask to be citizens of the United States. We was neutralized to be citizens of the United States. My family fought against the French. My family wrote the Constitution. You can look it up. If I say any word that is not true, you can deny my claim. And I'm saying to the state of Connecticut, I will hold you with $0. I'm asking you to let me give me my money back, but let me file a suit against you. You come in as a third-party plaintiff and you sue the people who are responsible for this damages.
So let me just,
I'm asking for $0 from the state.
So let me just, well, that's not necessarily true, but let me just unpack. I think what you're saying to us is that a court in this state issued a judgment against you and your assets have been taken as a result of that judgment, and you want this body to permit, through the claims commissioner, you to sue the state to undo that judgment. Is that fair?
Yeah, because now
Okay, well that's now I understand where we are. Okay.
Because the state have waited so long, 5 years. They just let it sit on their desk. So the first thing, if I file a case after this, I mean, the statute of limitation is told because the case is still ongoing. So it's still the same case. So it's still ongoing. So the statute of limitations have not expired, but they're going to have attorneys that say, hey, the statute of limitation. And I'm afraid that you're going to get another corrupt judge to go along with this because I done dealt with 5 of them. Okay. And I'm saying to the state, listen, this has to either come out of this court and you allow me to go to federal court because I am Tuscarora. So I'm saying work with me versus against me. If you allow me to sue you, you come in as a third party. That way, under the corruption, under false claims against the state, you have a right to sue those people. And we would both retrieve everything that we want, and it will cost the taxpayer $0.
Okay. Comment or question from members of the committee? Comment or question, Representative Porter?
Thank you, Mr. Chair, and thank you for being here today to testify. Question, how much is the claim?
Claim is 166 million. And that's because I was supposed to make 6 million for 16 years. Plus, under the statute, the amount doubles for that. So it come out to 1.6 million, I mean, 166 million, which the bank can afford to pay, or they have insurance. So the state will have no liability.
Okay. And is there anything else that you want to put on the record today while you're here?
I thank you for listening to me and giving me this opportunity to stand before you.
You're very welcome. Thank you, Mr. Chair.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? If not, thank you very much for joining us. I'm told that Rosa Klineski is in. So Ms. Klineski, you may provide your testimony.
Thank you. I'm sorry for the delay. I didn't realize I had to be here in person. I had prepared remarks for my partner. I apologize. I'm here in person now. This is a small claim that brings me in front of you today. It is $250. It is COVID related. In 2019, I was on disability, SSDI insurance, and Medicaid as well. So it was a time in my life when I was struggling. I had a disabling medical condition and I qualified for SSDI income. I was earning SSDI income. I was working at Home Depot at the service desk part-time to stay employed and to supplement my SSDI income. And as part of this SSDI income, I had Medicaid as my secondary insurance, which sometimes is referred to as extra help. It's something, what it means is when you're indigent, as I was at the time, you don't come out of pocket for medical expenses. Those expenses that would normally be paid by a Medicare Part B insurance plan or something are covered by extra help, which is Medicaid, which is federal money funneled into the state, as opposed to Medicare or federal money, period. So I got a COVID test because I was forced to get a COVID test. I don't have any particular reason to think I needed one. I was generally healthy. The medical facility forced me to get one. I didn't want one. I got one. I went to the facility. At some point later on, I was told that Medicare had not reimbursed the $250 for the test. I was told it was a billing or coding issue. By the time I could reach out to Medicare to fix the issue, the time period had elapsed to appeal the Medicare denial. And so my position was to then go to the state, and because now I had this $250 liability due to COVID that I didn't ask for. So I went back to the state and I said, well, you know, since Medicare is the primary insurance and Medicaid is the secondary insurance, anything out of pocket that would have not been covered by Medicare would be covered by Medicaid or extra help under QMB, qualified Medicare beneficiaries under that program. And therefore, this bill should be paid for by the state under extra help reimbursement state's Medicaid program. The state undertook itself. I know they have law clerks working at a discount. They wrote a 6-page brief as to why I shouldn't be paid the $250 and I don't qualify under QMB beneficiary status. So I'm making one last ditch effort to the committee in an effort for justice and the furtherance of justice. I would ask that in 2019, the only out-of-pocket medical cost I incurred was $250 for a COVID test. And I believe that it would be in the furtherance of justice that the federal COVID funds, which were earmarked for exactly this type of purpose, were utilized to give that $250 to me. I am not unjustly enriching myself. I did come out of pocket to pay that test. And now, as we know, COVID tests, you can get 10 of them for free anywhere, you know, from the government or whatever. They get them sent to your house. At the time, they were relatively precious and therefore worth money. I'm sorry it was so expensive. I'm sorry this took so long. My final position is the federal government is the initial payer, the state is the secondary payer, and therefore my claim should be paid. Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? I don't see any. I want to thank you for joining us and providing us with your testimony. It will help in looking at the file.
Thank you so much.
Robert Shea.
Thank you, members of the committee. My name is Robert Shea from the Claims Commissioner's Office, and I'm here to answer any questions that you may have. I would like to start briefly, if I could, on your agenda number 41. That is a wrongful incarceration award that we would ask the committee to consider and approve. That was a stipulated agreement entered between Mr. Police and his counsel and the state of Connecticut for $35,000. Excuse me, number 40. Yeah, number 41, Attorney Zoney already testified to, and we agree and support Attorney Zoney's testimony.
Okay, was there anything else you wanted to put on the record before we look for questions?
Well, yeah, one thing I would like, if we're going to go through each claim, or do you want me to? Oh, we're going to go through each one. Okay. Oh, you're saying no?
You mean each claim on here? No,
No, each one where people have testified. Okay, so I'm ready to work from that perspective.
Senator Kissel first.
Thank you very much, Chairman Winfield. And as I had indicated to you earlier, as I was walking out the door for a brief moment, I think it speaks extremely well of you that even folks that come here and are passionately arguing against the decisions of the claims commissioner yourself, or your staff members, the magistrates, or I don't know if we have another term for them now, but they all speak highly about you and the process that they went through. And so that's a huge step forward for this entire claims process here in the state of Connecticut. Sometimes in the past, and I don't blame any individual claims commissioner, but they would vent their ire on not only the process, but the people. And we haven't heard that at all this morning or this afternoon. So that really is heartening. Just a couple things. Why is the state on the hook for a wrongful incarceration when somebody lied in their testimony and the state relied on that lie? How is it the state's fault, or did I just miss something in how that all went down?
It's a great question, Senator. I don't believe the state was at fault in this claim at all. The state did nothing wrong. However, Mr. Staples was 100% innocent and he received a full pardon. And the statute can be interpreted to say if you're innocent, then you can make a claim under 54-102 UU.
All right, I agree with the fact that maybe that statute is unclear. I have a gut level problem with that. But that's for us to discuss at a later time. I think if the state is culpable, it certainly should be liable. But if the state itself, which is actually to some extent the embodiment of all the taxpayers, has committed no wrong, either intentionally or negligently, then I have a real hard time turning a claim into essentially some kind of structured welfare for certain individuals. Not to say that there wasn't an injustice, but it seems to me that the liable party is the liars that caused that whole thing to move forward. The other question that I have, going from 30,000 feet to just right on the ground level, my sort of approach to all of this is you and your staff are the triers of fact. And so I almost like put on an appellate court kind of hat that unless I see some clear violation of law that we're aware of, I'm very loath or hesitant to overturn facts when you're up close and personal regarding that. And so the matter that came down to the attorney who was speaking waived his fee and said this poor inmate, $6,000, hurt his back for a job that he was given to do, and I think it was McDougall Walker. And he said, you know, $15,000 would be more appropriate for this individual. You know, I'm as sympathetic as the next person, maybe more so in certain instances. I make no judgment because this individual is an inmate as opposed to someone in free society. Okay, we'll set all that aside, but you know, as much as that's appealing, and especially the fact that this attorney felt so motivated in this matter to say, I'm not even taking a fee. I have no grounds, in fact, to say, oh, 6,000 is wrong and 15,000 is right. I don't know, 21,000, a million. I don't know. So for us to like change our role from sort of an appellate review and sort of the other sort of hat that I think we wear here is sort of a traffic cop kind of thing where on some of these, I feel, and I have to discuss it with my colleagues throughout the leadership and the committee as a whole. I just feel like let them go to Superior Court because I think either the system sort of slowed them up for years and years and years, or it seems to me muddy enough that I'd like to see another either jury or judge weigh the facts. Just the one that comes to mind is the bicyclist, because I'm just guessing this guy was flying, he knew the bike path, he's probably going really fast. And so that's part of the comparative liability. And was he just going too fast to spot now that there was a gate? You know what? I think get everybody into a courtroom and figure that one out with triers of fact. But on this one little matter, is there any reason why we should doubt that the $6,000 award for that inmate is inappropriate? And is it okay for us, or at least my perspective of you guys grapple with these things and lose sleep over them, and that a lot of time and effort does go into this factual determination so that I can rest easy on a $6,000 award?
I agree with your perspective, Senator. I mean, I sat through this hearing and I came up with an $8,000 figure based on the evidence that I heard and the arguments from the attorneys, and discounted it for comparative negligence. There was some conversation from Attorney Tubbs about workers' compensation, which I thought was interesting. And I don't know whether workers' compensation law, where there is no discount for comparative negligence, whether that would apply in this claim. That was an interesting point. Other than that, I think the decision was fair.
And as much as, you know, you have Ed McEnany as one of your magistrates, one of my constituents whom I have the utmost respect for, former first selectman in the great town of Suffield, former probate judge for a variety of towns.
Navy veteran.
A Commodore, no less, as my Navy veteran as Chairman Winfield,
Right, exactly.
nuclear engineer of sorts, and general Renaissance man, and highly respected by myself and all of us in the legislature for many, many talents. But on this particular matter, you were the trier of fact. And so to me, no diminution of respect or for any of your other wonderful staff, whether they're students, and I know that gentleman introduced himself after the hearing last time from Enfield, whether they're paralegals, but it just gives it that much more weight when I know you grappled with this one. And if anybody's a softie, you're as much of a softie as I am. So I think $6,000 is probably appropriate. I'm looking forward to your answers to any other questions that folks have. I'm sure Representative Fishbein has just done a great job today, pulling out the threads of what's going on some of these things that aren't clear. And part of me, do you think that because there was, and again, last point, because there was a bottleneck for a number of years, and again, no aspersions against anybody who worked there previously, but for whatever reason, now the floodgates are getting opened up, because I had told some of our staff, and I shared with Chairman Winfield as well, on a claims day, you never know. I've been here where 3 people showed up and it was pretty quiet and we were done in 45 minutes. I've been here where we've gone even longer than today. And now we have the advent of Zoom, so we have folks that can be out in their law offices or in their homes and can just wait patiently. So that sort of makes these things go perhaps a little longer. But do you think that we're seeing the dam open up a little bit, and that's why we had so many folks coming to talk to us today?
I'm not sure about that, but I will say that, yeah, I'm very proud of what we're trying to do with the Claims Commissioner's office. Met some of the interns. They've been extremely helpful. The magistrates, we have 5 magistrates that are being very helpful and supportive of the mission of the Claims Commissioner's office to get fair and fast decisions out. They're doing this, they're full-time practicing lawyers, but they take time out of their practice to help out the state of Connecticut. And I'm grateful for all of them. And we have two amazing paralegals in our office. And they work very hard. They, along with getting these claims set up for decisions, they field, and you heard it today from some of the claimants, they field phone calls and emails from people to try to let them know what's going on. We respond to every phone call and every email, and that's a lot of work for Erica and Tara in our office. So yeah, I think we have a good system in place, and I'm happy about it. We have very good people. I've said it last week, the Attorney General's office is being very cooperative. They are doing everything possible to make sure that they're getting their information in to us so a claim can be decided or set up for a hearing. The claimant's bar is being cooperative. The claimants are obviously cooperative. So I think it's going great, thanks to the nice team we have in place.
Glad you got those plugs in there, and maybe the general public is not as aware of how lacking in certain supports and predictability we've had in the past, but I certainly see a brilliant future moving forward. Congratulations, Commissioner, and thank you for attending all day. Thank you, Chairman.
Thank you, Senator. Representative Fishbaum.
Thank you, Mr. Chairman. My bow. You know, I think the reason why we have a lot of people here today is you're getting a lot of cases out in your office, right? A lot of dispositions that we have the ability to address. So it is natural. But
So
I
just on that point that
Yep.
Senator Kissel says, yeah, so we dismissed or denied 363 cases since in 2023, in the first month of 2024. 83 people were appealed on this list, which is about 22% of the cases. So I don't know. That's just a statistic. I don't know how many appeals there are from the trial court to the appellate court in Connecticut, but it's 22%.
It would be interesting to see over the past 3 years whether that general percentage, not the amount of disposition and the number of appeals, but if that percentage rang true.
I'll
right?
check that out.
That would be
that would be interesting. You're right.
to look at.
See if there's a trend.
Yeah, so I just want to, you know, I've reviewed all the written backup, but we obviously had some people show up here today. We obviously had a lot of questions, and I'm just going to go through each of those, you know, give you an opportunity. Number 22 on our agenda had to do with the sidewalk defect, with the hole. And did you have anything to add with regard to that one?
Well, I'll tell you, there was some discussion between you and Attorney D'Elia regarding the process. I mean, what he said is true. I mean, I did get the hearing. I listened to the tapes. I reviewed every piece of evidence that was submitted, all the documentation, and I saw a very important piece of evidence was the photos of the crack in the sidewalk at Yukon stores. And ultimately I made the decision that I did not think that crack was a significant enough defect to give rise to responsibility on behalf of Yukon. So I denied the claim.
Okay. And I mean, I think it was characterized as not a crack, but a hole. How would you characterize it?
I characterize it as a crack. And I did cite a decision, in my opinion, from Judge Pittman, where she did a similar analysis where a small difference between one height level and another of 5/16 of an inch was not a significant defect. So,
yeah, I think industry standard, because I did a sidewalk case many years ago. It's got to be an inch or more is the industry standard to be a.
well, I didn't realize what the standard was, but yeah, I just respectfully, I looked mostly at the photo, Rep. Fishbein, and felt that was not the type of defect that would give rise to responsibility on behalf of Yukon stores.
And was there an actual measurement? Because like in that case, I actually put a tape measure in and like was able to show the deviation, or was that just you eyeballing that area?
I did not see a measurement with a ruler stuck in the hole. I did not see that in the photo. That might have been telling, but I have pretty good eyes, and it looked to me there were various different angles photos taken that are in our file, and I believe you have them. And it looked like a small defect that, not something that UConn would say, "Oh, we have to fix this, and we should fix this."
So, I'm wrestling with the due process issue in that case, right? And Attorney Delia, it does bring up a good thought. If you're gonna send a matter back to the tribunal to do the process correctly, no aspersions against you, right? We'll say to do the process as others have the ability to do the process, right? To have the actual hearer of fact be the trier of fact, right? Which is not what happened in that case. How do you deal with the fact that it's going back to the trier of fact that already made a disposition? How do I deal with that?
I could give it to one of our temporary deputies, hopefully soon to be classified as special deputies. I believe that at least one or more of them have no knowledge about this claim at all. And that would be a possibility.
Is it possible, once again,
They would not be privy to my decision, obviously. I would let them look at the evidence, or they'd have to retry it and just not have access to my decision. Now,
yeah,
if all of them know about the decision, then we'd have to maybe figure out a way to appoint a brand new deputy, which I can do that as well.
Well, I'm concerned about the public emolument issue, right? This particular case would be getting special attention based upon an individuality of that particular case, and the other side is the due process issue. So, I would be more inclined to send it back and to have no evidence of the prior adjudication be part of whatever's reviewed. That's where my head is at, right? Because I think it's.
When I said evidence, I meant we have an amazing claims management system that was set up by Commissioner Scott. So I wouldn't let them look at the evidence from the hearing, but all the pleadings and everything else that they filed, maybe I could ask the parties to refile that, but I don't think it would be necessary. They could have access to the pre-hearing documents and then separately submit evidence at a new hearing.
Yeah, okay.
See what I'm getting at?
That.
Yeah.
I mean, that's where my head is at. Where we end up on this, I have no idea at this point. The next one is number 32. Suing the state, Angel Cortez suing the state for essentially what I got from it was taking his children or having a custody determination. Did you want to add anything?
Those were child support orders that were entered by the state of Florida, and the AG's office filed a motion to dismiss, arguing that if you have a concern about child support orders entered by the state of Florida, you have a claim against the state of Florida and or a claim under what's called the Uniform Interstate Family Support Act. So what happens is that if a child support order is entered for a child in Florida, the state in the obliger, or the parent who has to pay the child support, lives in Connecticut, the state of Connecticut can enforce that order. And that's what I understand from Mr. Cortez's claim happened in this situation. I personally reviewed this claim myself, and there was some discussion when he testified about disability and workers' comp, but that the workers' comp claim had nothing to do with the claim that was filed with the Claims Commission's office. It was relating to child support being issued, an order being issued by the state of Florida being enforced by the state of Connecticut.
Okay, clear. Thank you. Thank you very much. The next one, number 19, Anthony Walker. I believe the root similar, a claim of no notice of the initial child support order. Did you want to add anything?
That was, I'll just say very briefly, that was a decision that we issued. And you're going to hear this a bit today, is that when people file claims with our office relating to conduct by judges, We generally dismiss those claims on the basis of absolute judicial immunity. That's a fact.
Okay.
If you have under our current
I know.
situation, in Connecticut, if you have a problem with the judge's decision, you have to go through the appellate process. You can't sue that judge or the court in the Claims Commissioner's office.
Yeah, if you have a problem with the decision of the judge,
right,
then there's an appeal process. If it's a magistrate, it goes to Superior Court judge, it goes to the appellate court, so on and so forth. You have a problem with the conduct of a judge, which a lot of these cases sometimes overlap. Then, you know, you can go to the Judicial Review Council and all that stuff. We had one of those.
What we would look at before dismissing a claim, we would look at if the judge's conduct was related to the judicial proceedings. If it is, then the judge has absolute immunity. But if it was something completely not related to the judicial proceedings, then that's another analysis. Potentially that you still might not be able to sue the state of Connecticut. You'd have to bring an individual claim against the judge under 4-165.
All right, the next one is the 4 tires,
Yeah.
number 72.
So, yeah, I worked on that claim myself personally too. So what had happened in that claim is Miss Minnelli filed a claim against the state. You know, you heard the facts of the claim. The AG's office filed a motion to dismiss, arguing that Miss Minnelli has a direct claim against the state under 13A-144, the highway defect statute. So I dismissed Miss Minnelli's claim, saying you have a direct claim against the state under 13A-144 in accordance with the AG's position. And also, what we try to do when that happens is, well, we always do it now, but the legislature has enacted a very good provision. If the Claims Commissioner's office dismisses a claim because we don't have jurisdiction under 4-142, the person can go into court directly and they have protection under the accidental failure of suit statute under 52-592 subdivision 8.
But what
So
guidance?
in other words, if the claim gets dismissed and then the person tries to go pursue their other claim, like they might be out of luck, but the legislature realized that was a problem some years ago and enacted section 52-592 sub E under the accidental failure of suit statute. So you can still get into court within a year.
Yeah, but the problem is that a lot of these people are lay people, right?
That's why I put it, we put it right in the decision.
So
to look at the accidental failure of suit statute.
Well, but that, and you know,
But I also have
this stuff.
All right, I'm going to remind you guys as well.
Yeah, sorry. We're debating, yes. Yeah.
Well, we're not debating, we're collaborating, actually.
Oh, I like that, yes.
When a claimant who's a pro se party, who doesn't have the training that you and I do, gets a document that says your claim is dismissed. However, see this statute, that word jumps off the page. The piece of paper goes in the garbage. They're frustrated, right? Really, what we should be saying to these people is your claim is granted, right? You do have permission to sue under the statute because they can't pull those additional words off of that document, right?
Oh, that's a good point. Yeah, I mean.
So procedurally, maybe you should be handling that when you have an alternative way to sue. You should be saying, yeah, you have the right to go sue under this statute. Amen. Right? And we wouldn't even, we wouldn't have heard her tragic story.
Very fair point. I don't know if the Attorney General's office would have an opinion on that, but I think that's a very fair point and I appreciate it. I think that's something we probably could implement fairly. You're right. They see a dismissal and they get mad. That's a good point.
Which brings me to another point that's very similar. You know, as I'm reviewing the claims that we have before us to review this session, which there are a lot of them. Something that we as a legislature had taken a position on starting about 3 years ago. The prior claims commissioner would dismiss claims if somebody had the ability to file in federal court. they would say that because you have an alternative means of relief, your claim is dismissed. But like a lot of those claims, you could bring in state court also. So we traditionally overturn those decisions of the claims commissioner. And I know we've got at least 2 of those in our, as I'm reviewing these for this year. So I just want to bring that to your attention. You know, it's got to be a bar to sue in state court in order for there to be a denial of that right. Just we policy wise have taken that position. So just want to bring it to your attention. On item 63, Clarence Austin, 1995 incident. He got out in 1999. I got it. Do you have anything to add with regard to that one?
I don't. It's
Okay.
statute of limitations.
Yeah, that's fair. Number 66, the gentleman was incarcerated in 2019. He got COVID-19 4 times. I was having difficulty figuring out what was going. I know it was a dismissal, but did you want us, before I go review that file in particular, did you want to say anything?
Well, yes, thank you very much. We had a hearing on that claim, in person. And I just did, based on the evidence, I did not see that there was anything that the Department of Correction did improperly in the way they treated Mr. Bernardo during this very horrible time for the state of Connecticut. So that's why I made that decision.
It was a horrible time for all. I mean,
For everyone.
you know, I got those calls, you know, those text messages from Commissioner Quiros where, you know, somebody died in custody from COVID-19 last night, and, you know, just want to let you know. And, you
But
know,
I do, as we're probably both aware, there are pending lawsuits based on the way Department of Corrections handled other people that are incarcerated, and that they may succeed. But in this particular claim, I did not see, listening very carefully and reviewing the evidence, that there was anything in this particular claim that the Department of Correction did improperly.
okay. Number 1 on our agenda, Yolanda Ortiz. Did you want to mention anything about that one?
I think that was the statute of limitations.
Okay,
This is-
so the statute allows us to flex it though, doesn't it? So it's a 1 year, but up to 3 years. And I think based upon at least what I heard, and I haven't reviewed the file, that she was slightly outside the 1 year.
I'm just going to pull it up, the decision right now, Representative. Give me one moment. I didn't work on this one. That's why I just have to look at it quickly.
I mean, I can look at it myself. That's my understanding of her testimony.
Yeah. I'm looking at it. That's what we understand as well. is what happened.
Are you looking at it or you just,
Well, the decision doesn't say much. It refers to the Attorney General's motion to dismiss. So I'm just looking at the Attorney General's motion to dismiss.
yeah, that would probably is straight. She's outside the 1 year.
I believe so. That's what
Yeah.
I'm seeing as I scroll through it.
And those are usually relatively quick documents. It probably has when the pin dates.
What, if you don't mind, if I could get back to you.
Yeah, that's great.
Specifically on this
Yeah.
one, yeah, I don't want to hold up the
Good
committee
idea.
right now, yeah.
Number 22. 11 years of wrongful incarceration. Anything to mention about that one? That was Haiti Silva.
Haiti Silva, she was the, that was the fall down in, Yukon, number 22.
That is correct. Okay. Maybe it's number 10. Yes, number 10, Eric Westry.
Yeah, that, it, I made this decision, that I believe the claim accrued on April 5th, 2016. I know you had a lot of discussion with him. That was the incident date that triggered the requirement to file the claim. The claim wasn't filed until 2018.
Okay. And that was the sole basis for dismissal?
That was the sole basis, yes.
And number 68. Was the matter that Attorney Vance was here on.
By the way, Attorney Vance has been extremely helpful to the Claims Commissioner's office. He's a great person. He's been very helpful. So is Commissioner Scott and Commissioner Smith. I've been
Perhaps the
talking with all of
denial
them.
of your appeal of his
I did
claim
not
is a
work.
testament.
I did not work on this claim.
Well,
so
take the testament anyway.
yeah, yeah.
Testament to truth, justice, and the American way. What did you want to, if anything, add with, because that one, that's an analysis case. So I'm gonna have to, I've got a 4-page document from him. He says that you're wrong on the law.
It sounds like we didn't have it sounds like we didn't have a hearing on this claim, which
Yeah.
to be honest with you, in claims like this, we're now trying to set up hearings on anything like this. You know, so, I mean, I think based on what our deputy had seen that was presented, you know, he believed that the Southern Connecticut State University couldn't be responsible for Mr. Dinello's injuries.
Well, what about the quality of the submissions? I mean, part of the contest is you have individuals who may or may not have a particular acumen to opine on a premises liability issue. And then he brings in somebody that he claims has the acumen. Neither side is able to cross-examine, which you would have at a hearing, right? And the reviewer takes the submissions for what they are and determines the case based upon those submissions. So where is the due process there?
Well, I agree with you 100%. I mean, I like to have hearings and, but there are provisions in 4-160 that allow certain claims to be cited on the papers. So
I guess that's the other issue, because if
Yeah.
he had claimed maybe a number that was within your statutory authority, then maybe we wouldn't be here and a different determination would have been made.
I think
Right.
there's also some provisions that say that if a claim is a certain number of months old, that it can get referred to a magistrate, could be made, a decision made on the papers, and it's not. So I think maybe that happened here. I prefer personally to have hearings, and they're very easy to have. I mean, with teams and in our office, and so I hear you. It feels like it's a kind of a claim that maybe should have had a hearing.
But are we statutorily bound to not send it back? There is no procedural defect. Perhaps it's a due process defect, right? It's not like the other case where technically it should have been a mistrial, right? That's a procedural defect. Here we have the system took in evidence, made a decision. I think under the review statute, we only have the power to affirm, overturn, or vacate. right? We don't have, I don't think we have the power, so long as the process was followed, to send it back to you in a remand.
I don't know exactly. I haven't focused on what exactly your power is, but that's,
So now I'm left with overturning the decision of the claims commissioner and giving the right to sue, affirming the claims commissioner, and which would terminate that due process concern, not to my satisfaction. How do we get there? That's the question. If we all agree, well, at least us. I don't know what they think.
yeah,
They don't want to do it. Yeah, I know.
they don't mind doing hearings.
I
I don't think. I don't want to speak for them, but they're good at doing hearings. Yeah.
They're the largest law firm in the whole state of Connecticut. So anyway.
They're the best too.
I don't know how we get there. So we're gonna have to look at that, because I would like the claims commissioner to have an opportunity to have a hearing on that issue at least. But I don't know under our confines whether we get there. And then the tier 1 to tier 2, the pension situation.
Oh, yeah. Let me pull that up if I could. I'll just
Yeah,
hear
absolutely.
exactly what the decision was. Yeah.
Yeah.
That was
That's
number
number
75.
Yeah.
So there's a statute that tells us what areas of the law, what types of claims that the Claims Commission Office does not have jurisdiction. It's 4-142. So our office in this claim dismissed this claim for two reasons, two different provisions under that statute. One is the Claims Commissioner does not have authority to hear claims, quote, for the periodic payment of disability, pension, retirement, or other employee benefits. We also don't have jurisdiction to hear claims when there's a claim, quote, for which an administrative hearing procedure is otherwise established by law. So there were two reasons why our office dismissed this claim, because it's a pension issue. We don't have jurisdiction over, pensions. And if the state of Connecticut has otherwise established an administrative procedure for someone to pursue, then we also don't have jurisdiction over that type of a claim. And
So what is the administrative procedure that you would have the claimant follow?
I would think, let me see if it's described. Through the Employee Retirement Commission. Well, let me, you know what? Let me follow up and get precisely what administrative procedures would be available under this type of claim. I don't want to just shoot from the hip, Rep. Fishbein. But we did dismiss it on a completely separate basis that we don't have jurisdiction over pensions. See what I'm saying? There's two separate reasons why we dismissed this claim.
And the claimant is saying, I'm exempted from that portion of the statute because I'm claiming that the state of Connecticut breached its fiduciary duty. Is that a little bit different?
Well, I can read from our decision very quickly. The claimant attempts to avoid her obligation to exhaust her administrative remedies by casting her claim as a tort is unavailing. She accuses the state of failing to manage the determination of her pension eligibility and the timeliness of her payments properly. An administrative process exists to challenge such failures. She is obligated to make use of such procedures as is every other recipient of a state-funded pension. So
But I'm trying. So the claim there, though. I mean, there's
yeah,
two. par-
so
there-
is there a separate breach of fiduciary duty claim?
I mean, the
I,
two
we,
harms
I guess
that
we decided that there isn't based on that statute 4-142.
well, there should be. The two harms that I recognize are the state's failure to act upon the signature of the individual in shifting into the other pension. And then in the wake of its negligence, malfeasance, whatever you want to call it, charging the individual $70,000 to correct their error. Those are two bad things, in my opinion. So
There was also, I will say, I'm looking at it now, there was also a statute of limitations issue.
okay, so let's talk about that.
But we didn't get to that. We said we don't even have to reach the statute of limitations issue because we're dismissing it because we don't have jurisdiction. But I did hear Attorney Presley say that he finally found a good man later on who admitted that so.
Well, the
you know,
statute of limitations issue in that case, I think, would have been that back in 1984, let's just say, because she was an employee, she did this in 1982, 1983, 84, and then thereon, she knew about the lack of switching from tier 2 to tier 1, and therefore that's when the
Maybe
statute
that's when it
starts to
accrued.
run, right?
Fair enough, but we did not reach that in our decision.
However, you would have a teacher who's an active teacher have to bring a claim against the state because of their lack of ads. That's more like a mandamus action, quite frankly, right? It's not a delegable, it's not a discretionary duty. So, and the claims commissioner doesn't do mandamus actions, right? They're cases for damages.
I thought I heard Attorney Presley say they filed a declaratory judgment action, which didn't succeed. So
With some other tribunal, I think, with
maybe the Retirement Commission.
maybe the Board of Labor Relations too.
I'll get some more information on this one. I hear what your concerns are. I'll get some more information and send it to the committee.
I mean, to say to, I mean, just, you know, in the wake of us screwing up, basically, that you had to have retired early and not serve as a teacher for 3 additional years. I just, public policy wise, I got a lot of problems with that.
Fair enough. Again, I will go back to the statute 4-142A1 that says we don't have jurisdiction over pensions. The Claims Commissioner's Office. I don't think you folks want us in these fights. That's
Well,
one, yeah, that's why that's one way to read that provision in the statute. That there's a retirement commission set up, or the Board of Labor Relations, or maybe even the comptroller's office. I mean, there are other places to go than the Claims Commissioner's office if you have a concern about your pension. That's the way we interpreted that provision.
Yeah, I
Rep. Frischbein, but maybe we,
I don't think that's the intent. I mean, when a state employee screws up, I don't even know who is alleged to have screwed up, causing somebody to be damaged, and then you just say by statute, you can't do that. I mean, you know, that's like saying you can't go to the claims commissioner for anything having to do with correction, which would be really bad. Anyway, I'm wrestling with these last.
take a look at that provision though. You're right. I mean, it's at 4-142A1.
Yeah, no, I wrote it down. All right, that's it. Thank you. Thank you, Mr. Chairman. Thanks, Bob, for being here.
That's it?
Thank you, Representative. Commissioner, did you come here with the ability to talk about any of the claims on here?
Yes.
Okay. And this is particularly because I don't want to break the way that we've done things, and we've denied some folks today who've already left. And I see Mr. Trailer there, so I want to talk about his for a second. Because he's not going to be testifying, at least not right in front of everyone. But can you talk to me about the denial? Because I remember when he was before Judiciary he'd been in front of Judiciary for a while. And in this particular instance, he had made a claim about the way that his interaction in the courtroom went, and the judge denied it, and he suggested that he was telling the truth. And we said, okay, we'll go back and look at the transcript, not thinking that the actions would be in there, but lo and behold, they were, and we discovered that the judge was not being truthful, and that judge got stopped. So having remembered that, and finding him on multiple instances to be truthful, I'm curious about the denial in his case. It's number 77 on our list.
Thanks.
Yeah, this is claims against decisions by judges in the Superior Court. So we dismiss this on the basis of absolute judicial immunity.
So the claim itself was against the decision that the judge made?
Various rulings of judges of the Superior Court and the appellate courts
Okay.
over the course of several years, yes.
Okay, and I asked that because I read his submission and just wanted to be clear what it was so that I'm oriented correctly. Okay. Comment or question from other members of the committee? Comment or question, Representative Porter.
Thank you, Mr. Chair. And this may have been already covered because I stepped out of the room, but I just wanted to make sure. I wanted to go back to number 28, the young man that we heard from, Elijah El-Haj Bey. Just wanted to know if there's anything you want to add to the record.
Yeah, that was a similar situation. There were allegations made against decisions by Superior Court judges between 2011 and 2019, I believe. And so we dismissed the claim on the basis of judicial immunity.
On the basis of
Judicial immunity.
immunity?
Essentially, the way the law.
That you quoted, I'm sorry about.
Excuse me?
I said, I'm sorry, I didn't mean to cut you off.
No. Essentially what the laws in Connecticut, it's not absolutely ironclad, but if a person does not like a decision of a judge, that you can't sue the state of Connecticut claiming that the decision was wrong. You have appellate rights. There's other avenues you can seek, but you can't come to the Claims Commissioner's office and say, I want to sue this judge because I disagree with his or her decision. So that's general common law in Connecticut. So when we see claims come into our office where citizens are, probably reasonably upset with decisions of judges, we generally dismiss those claims because of this common law that you can't sue judges based on their decisions. Now, if they have other conduct that's not related to their decisions, that's a different story.
Okay.
But when a claim comes in about a decision, we have to respectfully dismiss those decisions.
And
It's a complicated concept, but and again, to Rep. Fishbein's point earlier, we can be less lawyerly in the way we write our decisions. I've been trying to do that, but I want to make sure that people understand why they can't succeed in a claim against the state.
And I do believe it was stated earlier, but just for clarification, are they advised at that time that they do have a right to sue or to go to the appellate court? or is it just a dismissal?
We don't really, the decisions that we've issued since I've been around for 10 months, we don't tell them per se that you can go to the appellate court, because I also don't want to lead people down the primrose path that you can go to the appellate court and the time may have passed for them to file an appeal in the appellate court.
So is that the case here? Is there a statute of limitations that would hinder?
Well, I think
Mr. Bay?
the conduct, let me just make sure, I think I have the years correctly. Let me look up his.
Thank you.
And this is, what number is his again?
Number 28, Senate Joint, I think it's 180. Yes, 180.
I was right about that. Yeah. So the claimant had made claims against court decisions between the years 2011 and 2019 relating to the case of Windsor Federal Savings and Loan versus Reliable Mechanical Contractors. So it was over a long period of time that Mr. El-Haj Bey had concerns with court decisions in that case. So respectfully, if we told him in our decision, hey, you can go to the appellate court, that may not be true, because you have to file appeals within a short period of time after a trial court makes a decision. So you don't want to point person in a direction that is fruitless. So give them false hope, right? But you know, I hear this committee loud and clear. Yeah, it seems like most of our claimants don't have lawyers. And you'll see in our decision, they're pretty short. We're not citing a lot of cases. We're trying not to use too much legalese, but we can do better. And I really like Rep. Fishbein's suggestion that if we're telling someone that they have a claim under the highway defect statute, we should say, you have a claim under the highway defect statute. A similar statute is, there's a statute 52-556, which allows people to go directly into court when they get in a car crash with a state vehicle. So instead of saying the claim is dismissed, you could say
redirect them.
You're allowed to make a claim directly against the state under 52-556. So I do really appreciate that suggestion. That'd be fair to our pro se claimants.
Yes, I agree. Last question. The statute that you referenced around the what did you say, judicial immunity?
There's no statute. It's kind of, it's decisions. I don't believe there's a statute, but I believe it's decisions over many, many years by
So this is
our
just
Supreme Court. It's
practice.
called common law. It's what the courts and the policy has decided that when judges are making decisions within their job, within their judicial discretion, if you don't like his or her decision, you can't sue the state for that.
But you can go to the appellate court.
If you're within the time limit, yes.
Okay.
Yeah.
Thank you
Right.
so much. Good to see you.
Good to see you too. Thank you.
Thank you, Mr. Chair.
Thank you, Representative Porter. Comment or question from other members of the committee? Comment or question from other members of the committee? If not, Attorney Shea, thank you for joining us again.
Thanks for inviting me. I appreciate it. Have a nice weekend, everyone.
So the names that are still on the list that I have left are Clive Milton, Louise Ortiz, and Michelle Milton. Now, as I said, I know that there have been others who come here today. And as we have always done, I suggested to folks that they did not testify and would not be able to testify. Having said that, I will stick around here if there's someone who, as I see Mr. Trailer, who I know, who wants to have a conversation and make sure that the committee is aware of what they are putting forward. But to do differently would, I think, be unfair to those who have not had the chance to sit here and then get a chance to testify. So I will not leave. I will be here until everyone is satisfied. With that, I will call this hearing